I apologize for the belated getting out of the blocks. I'm trying to unwind some confusion that I created last Wednesday. I had announced on the floor that because there were some issues raised about the use of proxies, that we would revisit those bills that were handled last Wednesday where a proxy was voted. There are two sets of bills. There were those that got to the floor of the Senate, which have been recommitted to this committee for consideration, and then there were bills that were not reported, which we will need to reconsider. So the posture of the bills that were reported to the floor is they have been recommitted. Consequently, I would ask that someone make a motion to reconsider the vote by which the Senate Courts Committee on handled the following bills: 95, 323, 445, 548, 554, 467, 183 and 184, which were re-referred to the Committee on Finance, 159, 224, 251, and 459. What has been distributed to you is a list of those bills, and affixed to it is the summation of the vote on those bills, and also the way that everyone voted when those bills came before you. So if you want to digest that just for a minute, and I will try to muddle us through that, and while you're looking at that, I will respectfully ask the clerk to call the roll.
Senator Saslaw? Senator Marsh?
Here.
Senator Howell?
Here.
Senator Lucas?
Here.
Senator Edwards? Senator Puller? Senator Obenshain? Senator McDougal? Senator McEachin? Senator Stewart? Senator Vogel? Senator Stanley? Senator Reeves? Senator Garrett? Senator Normant? You have a quorum, Mr. Chairman.
Apologize on the sheet that was distributed to you. I said Senate Bill 95, it was Senate Bill 94. Oh, no, just found that one. I apologize. All right, let's see what we can do here. The first bill is if there would be a motion to reconsider the vote by which Senate Bill 94 was reported, and it was reported on a 14-1 vote. Okay, it's been moved and seconded that we reconsider Senate Bill 94 by which it was reported to the floor on a 14-1 voted. Is there any discussion on this? This was a bill dealing with the rules of evidence. It's been moved and seconded that Senate Bill 94 be reported. All in favor, please signify by saying aye. Aye. All those against, and note your objections. That bill is reported 14-1. Next is Senate Bill 323. That was Senator Carrico's bill, which was the one gun a month vote, which was reported on an 8-7 vote. I would ask that someone on the prevailing side please move to report that bill. It's been moved and seconded that Senate Bill 323 be reported, and once again, that was the one gun a month bill, which was reported on 8-7. Is there any discussion? Hearing none. All those in favor, please do a roll call, please.
Senator Sasslaw? Senator Marsh? Senator Howell? Senator Lucas? Senator Edwards? Senator Puller? Senator Obenshain?
Yes.
Senator McDougal?
Yes.
Senator McEachin? No. Senator Stewart?
Yes.
Senator Vogel? Yes. Senator Stanley?
Yes.
Senator Reeves? Senator Garrett? Senator Normant?
Yes. That bill is reported on an 8-7 vote. 9-6, excuse me, I forgot. Senator Edwards, apologize. Next is Senate Bill 445. Senate Bill 445.
Move for report. As amended.
Pardon me? We're going to take it up in the form with the amendment already been adopted. Is everyone all right with that, unwinding it back to the amendments and the substitutes? If anyone has any objection, will they please voice it now? Okay, we will take it in the amended form. Senate Bill 445 was Senator Vogel's bill dealing with protective orders, and that passed out. Looks like it was a 13-0 vote. It's been moved and seconded that we reconsider that vote by which it was reported. All in favor of reconsider it signify by saying aye. All right, it's been moved and seconded 445 be reported. All those in favor of reporting 445, please signify by saying aye. Aye. And that bill is reported on a 15-0 vote. Next is Senate Bill 548. Senate Bill 548 was Senator Northrum's bill, which was dealing with assault and battery, a felony, when certain classes are certain classes of people are victimized. As I recall, it was prison contractors on that. That bill was reported out 14-0. 547, excuse me, I'm sorry, I flipped over to 547, I apologize, my mistake. 547, I apologize, that was Senator Northrum's bill also, and that was the one dealing with the assault and battery on another protected class, was 15-0. May I have a motion that we report that bill and re-refer it? Okay, it's been moved and second that 547 be reported and referred. All those in favor, please signify by saying aye. Aye. Okay. Next is Senate Bill 548, which was also a Northrum bill, and that was the conveyance of some property in Accomack, as I recall. If I could have a motion on that, please. It's been moved and seconded that 548 be reported. It was reported from the courts of justice previously with amendment. All those in favor of reporting 548 with an amendment, please signify by saying aye. Aye. All those opposed, and that is reported. Next is Senate Bill 554. Senate Bill 554 is Senator Fiola's bill. It's a transportation dealing with firearms in the emergency protective order. It was reported with 9-6 with 3 line amendments on that. If I could have a motion on that, please.
Move report. Second.
It's been moved and seconded that 554 be reported, which previously had been reported on a 9-6 vote, and the previous vote is on the list that I have. All those in favor of reporting Senate Bill 554 with the amendments, please signify by saying aye. Aye. All those opposed?
No.
Okay. If the noes would please show by your hands on that. 554. Those who voted against it were Edwards, Obenchain, McDougal, Vogel, Stanley, and Garrett. Still 9-6?
And
9-6? Excuse me? Okay. And that bill is reported on a 9-6 vote. Next is Senate Bill 4. Next is Senate Bill 4. Senate Bill 4 was previously reported on a 8-7 vote. It had a substitute that was adopted rolling in Senator Stanley's Senate Bill 64. This was the Castle Doctrine bill that was previously before us. Hold on a second, I'm trying to find the damn vote. For some reason that page is missing in my stack. That bill was previously reported with the nays being Sasslaw, Marsh, Howell, Lucas, Edwards, Puller, and McEachin. All right, it's been moved and seconded that Senate Bill number 4 be reported with the substitute incorporating 664. All those in favor, please signify by saying aye. Aye. All those opposed? Is it anyone who changed their vote? I can do a roll call if you would like. It's reported 8-7. Next is Senate Bill 67. Senate Bill 67 was Senator Stanley's bill dealing with concealed handgun permit applications on fingerprints. It was a substitute that had Senator Garrett's Senate Bill 670 rolled into it. And that came out on an 8-6 with 1 abstention. If I could have a motion on that bill, please.
move to report as with the substitute.
So it's been moved and seconded that Senate Bill 67 be reported, which had a substitute incorporating Senate Bill 670. All those in favor of reporting Senate Bill 670, please signify by saying aye.
Aye.
All those opposed? Previously, Senators Sasslaw, Marsh, Howell, Lucas, Puller, and McEachin had voted no. Has anyone changed their vote on that? Okay. So that bill will be reported on a 9-6. Next was Senate Bill 183, which was Senator Stewart's bill. That was reported without amendment and referred to the Committee on Finance, and that passed on a 15-0 vote. May I have a motion, please? It's been moved and seconded that Senate Bill 183 be reported and re-referred to Finance as it previously was done on a 15-0 vote. All those in favor, please signify by saying aye. Aye. All those opposed? And that's reported on a 15-0 vote. Next is Senate Bill 184, which was reported and re-referred to finance. That was Senator Stewart's bill, which dealt with court interpreters, that the cost of the interpreter for non-English speaking defendant be assessed to the defendant if he's convicted of a criminal offense. And that bill was reported on a 8-7 vote, with Senators Sasslaw, Marsh, Howell, Lucas, Edwards, Puller, and McEachin voting no. All those in favor of reporting Senate Bill 184 and referring it to finance as it was previously done, please signify by saying aye. Aye. All those opposed? And has anyone changed their vote on that? Do I need to do a roll call? Okay, hearing none. Senate 184 is reported and re-referred to finance. Next is Senate Bill 547, which we already did. Somehow it got out of sequence, and I apologize. Okay, next is Senate Bill 159. Senate Bill 159 was reported with a substitute and re-referred to the Committee for Finance, and that was reported on a 14-1 vote, with Senator McEachin being the dissenter on that. If I may have a motion on that bill, please. It's been moved and seconded that Senate Bill 159 be reported and re-referred to Finance with the substitute that had been adopted. All those in favor, please signify by saying aye. Aye. All those opposed? Senator McEachin votes no. So that bill is reported and re-referred. Next is Senate Bill 224. Oops. That one was okay. Okay. How about 251? Okay. Okay. Next is Senate Bill 251, which was Senator Obenchain's bill dealing with circuit court fees, which was reported with a substitute on a 15-0 vote and was re-referred to the Committee on Finance. May I have a motion on that, please? Okay, it's been moved and seconded that 251 be reported and re-referred to Finance, and once again, the previous vote on that was 15-0. All those in favor, please signify by saying aye. 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 All those opposed, and that bill is reported and re-referred to Finance. Next is Senate Bill 459. Senate Bill 459 was Senator Herring's bill that we spent a considerable amount of time on, which dealt with domestic assault and battery and strangulation. A substitute was adopted and reported and re-referred to Finance on a 15-0 vote. If I may have a motion on that, please. It's been moved and seconded that Senate Bill 459 be reported and re-referred to Finance. All those in favor, please signify by saying aye. Aye. All those opposed, and that bill is reported and re-referred to Finance. Does that take care of all those problem children? Did I miss one? That's a miracle. Now, somewhere in here, I have today's calendar. Yeah, let me get the right batch here. Okay. Trying to find Black's bill. On Senate Bill 460, it failed on it to report on a vote of 7 to 1. Is there a motion on that bill by the prevailing side, which the prevailing side would be a failure to report the bill? Hearing none, that bill remains as is. I'm sorry. 364? 360. Okay.
Yeah, I hope so.
The pro- I'm sorry, did you say 360? Yes, excuse me, is that the one? That was a fail to report. Yeah. Let's see, where's your list with 360 on it, and who voted? Well, I need the breakout on the votes. Do you have the vote on 360? $360. Next would be Senate Bill 360. This was Senator Deeds' bill, which dealt with the Judicial Inquiry and Review Commission, and I think you all recall the question was whether or not a judge should be able to testify on that. That bill failed to report on a 6-9 vote, with Senators Saslaw, Marsh, Howell, Lucas, Puller, and McEachin voting in favor of that. So may I have a motion to reconsider that, please? It's been moved and seconded to reconsider 360. All those in favor, please signify by saying aye.
Mr. Chairman, who made the motion? Who made the motion?
The motion is to reconsider 360. All in favor of reconsidering 360, say aye. Okay. Now,
Mr. Chairman, excuse me. Who made the motion?
it failed. Senator Obenchain did. He voted no previously. Do you have a question about that,
No.
Senator Marsh?
I just want to make sure.
He was on the prevailing side on that bill. Okay. May I have a motion on Senate Bill 360? A motion to do something, please.
Move the report.
It's been moved and seconded that Senate Bill 360 be passed by indefinitely. Was there a substitute motion? Hearing none. All in favor of reporting Senate Bill 360, which previously died on a 6-9 vote, please signify by saying aye.
Aye.
Everyone down that way voted aye last time. Okay. Everyone in favor, please signify by saying aye.
Aye.
It's the motion is to PBI. You at that end do not want to vote for that. Okay. All in favor of PBI 360 signify by saying aye. Aye. All those opposed,
No.
the bill is defeated 6-9. Thank you. What's next? Had some kind of what? Next, if I could direct your attention to Senate Bill 21. Senate Bill 21 was Senator Stewart's bill, which is dealing by rape by coercion, and this bill was continued over into 2013 on it. If I may have a motion to reconsider that, please. Moved and seconded to reconsider Senate Bill 21, which was carried over to next year for a 15-0 vote. All those in favor signify by saying aye. Aye. All those opposed. And the bill is reconsidered. If I could have a motion to continue it until 2013, please. Moved and seconded, the Senate bill once again be continued until 2013, which was previously on a 15-0 vote. All those in favor, please signify by saying aye. Aye. And that bill is continued over until next year. Next is Senate Bill 324. Senate Bill 324 was Senator Carrico's bill, limitation on administrative actions relating to firearms. This bill was also carried over until 2013 on a 15-0 vote. If I may have a motion to reconsider, please. Moved and seconded, we reconsider Senate Bill 324. All those in favor signify by saying aye. Aye. All those opposed, and that bill is reconsidered. May I have a motion that Senate Bill 324 be continued over till 2013, and it was previously on a 15-0 vote. Moved and seconded, Senate Bill 324 be carried over until 2013. All those in favor, please signify by saying aye. Aye, and that bill is carried over again. Next is Senate Bill 439. Senate Bill 439 was Senator Obenchain's bill, which was passed by indefinitely. If I could have a motion to reconsider that bill, please. It's been moved and seconded that Senate Bill 439 be reconsidered. All those in favor signify by saying aye. Aye. All those opposed, and it's reconsidered. If I could have a motion that Senate Bill 439 be passed by indefinitely, which it was previously done on an 11-4 vote.
Mr. Chairman, could I make a motion, a report, and could I ask just real quickly, without delving into debate, just a question to Senator Howell, if I may, and just to clarify something that was, I may have given a mistaken impression last week, and I want to make sure that I clarified this. This deals with the law enforcement powers for Medicaid fraud investigators. I would ask, I may have mistakenly said this was a crime commission bill. My understanding is that it was a matter, a principle that was submitted to the Crime Commission in concept and unanimously approved by the Crime Commission, but that there was no bill placed before the Crime Commission.
Mr. Chairman, that's correct, Senator Obenchain. We had a report on this subject from staff. Nobody on the Crime Commission had any heartburn about this matter, but we didn't draft our own bill. So as a result, it's not a Crime Commission bill, and I thank you for asking because I think I was uncertain also. But I would just repeat that there was no particular concern about this because the authorities that these investigators would have are very circumscribed. It may be a good idea to scale it back in other ways, but you're correct.
Mr. Chairman, with that admonition from Senator Howell, what I would propose is an amendment to this in order to address some of the heartburn that may have been expressed, and that would be to add a 4-year sunset to the law enforcement powers that are extended in this.
Mr. Chairman.
Okay, it's been moved and seconded that an amendment.
Mr. Chairman.
It's been moved and seconded that an amendment to 439 be adopted, which would have a 4-year sunset. Senator McEachin.
I'll wait till you adopt the amendment.
Okay. Is there any further discussion on the adoption of the amendment? If not, all those in favor signify by saying aye. Aye. All those opposed? No. Show your nose, please.
Chairman, I've moved to, I'm sorry.
Do you have the roll call on that one, please? It's been moved and seconded that 439 be reported with the amendment just by way of revisiting. Previously, those that voted in favor of the bill were Senator Obenshain, Stanley, Reeves, and Garrett.
Mr. Chairman,
Senator McEachin.
I would make a substitute motion to pass the bill by indefinitely, and speaking briefly to that motion.
It's been moved and seconded that Senate Bill 439 with an amendment be passed by indefinitely. Senator McEachin.
Mr. Chairman, thank you. Just to remind the committee members, I think the heartburn with this bill was the notion that these officers, among other things, could carry guns into nursing homes and places like that, as well as the notion that they would have the ability to enforce the laws of the Commonwealth wherever situated, and not just for the investigative piece that admittedly is the focus of Senator Obenshain's bill. I hope it'll be the pleasure of the committee to pass the bill by indefinitely.
Thank you, Ms. Senator McEachin. Did you want to say anything? Senator Obenshain.
Mr. Chairman, just would remind the members that these are folks who are limited strictly in terms of the responsibilities that they can perform by federal law, and they are required to conduct these activities out of this particular office. And if they exceed the scope of those limited duties, they jeopardize any of the funding. This is fully funded by federal law or federal dollars and by money that's essentially recovered by this Medicaid fraud unit.
Mr. Chairman?
Senator Edwards.
One other issue here, and that is all law enforcement authority at the state level are controlled by the governor through his executive powers. The state police, for example, report through the Secretary of Public Safety to the governor. We've never had a situation where a law enforcement authority with this kind of power, the power of sworn law enforcement officials reporting directly to the Attorney General, who has a separate responsibility, independently elected, and this would be a precedent in Virginia. It would be an unwarranted precedent to give to the Attorney General's office these kinds of authorities. The Attorney General's office can rely upon and does rely upon the state police and other law enforcement authorities in order to investigate crime, but he himself has never had this kind of authority. I think it'd be unwarranted to do so.
Senator Obenshain, if we need to move this bill along, it's been previously discussed, and I don't know that the amendment's going to change much, but Senator Obenshain.
I would just remind the members that this is not something that the Attorney General's office asked for. It is a responsibility that was given to them and mandated by the federal government. And because of that federal governmental mandate, we have essentially law enforcement officers who are being placed in a situation of having to investigate organized crime, going into situations where they are not authorized to carry a weapon. It is dangerous, and they're required to do it. It is required by federal law to be conducted out of the Attorney General's office, and we just don't have the latitude to do it otherwise.
You know, we've been going through bills that we did last Wednesday, and this is the only bill that seems to be worthy of any further discussion.
Yes, ma'am.
I think that's not right.
I appreciate it. The chair is exercising this discussion, Senator Pruitt, but I appreciate your comments very much.
Mr. Chairman,
Senator Marsh.
we've never let the federal government jerk us around before. Why are we doing it now?
I take that as a rhetorical question.
Mr. Chairman.
I'm sorry, somewhere. Oh, Senator Garrett.
Yes, sir, Mr. Chairman. The bill references Code Section 32.1-321.1, which is already existing in the Virginia Code. So we've already made this the law, and I don't want to read it to the folks here, but essentially It is already codified in Virginia to cooperate with the federal government, other state agencies, and the state attorney general's office, et cetera, so forth and so on. This is already the law. All this does, in fact, since 1982, the Medicaid Fraud Unit of the Attorney General's office has been policing these crimes. I spoke to it last Wednesday. I don't want to take too much time, but this law enforcement action occurs in conjunction with primarily the FBI and not the state police or sheriff's offices. If the members of the committee would look at 32.1-321.1, they'd see it's already there. All we're doing is allowing law enforcement professionals to protect themselves in otherwise, I will not yield right now, in otherwise difficult situations.
Senator Lucas, did you want to say something?
Mr. Chairman, I think we're out of line here. I think we need to call for this question. We haven't done this on other bills.
Senator Lucas, I'll run the committee. Thank you for your input. I appreciate it very much.
You're very
ma'am.
welcome.
Thank you.
Sir.
It's been moved and seconded that Senate Bill 439 with an amendment be reported and re-referred to Finance. And once again, this previously was passed by indefinitely on a 4-to-1 vote, with Senator Obenchain, Stanley, Reeves, and Garrett voting in favor of, and everyone else voting against. Okay? All right. All those in favor of passing the bill by indefinitely, which was a substitute motion made by Senator McEachin, signify by saying aye. Aye. All those opposed? No. Roll call.
Senator Saslaw.
The motion is whether or not to pass it by indefinitely, which was a substitute motion by Senator McEachin.
Senator Marsh.
Aye.
Senator Howell. Aye. Senator Lucas. Aye. Senator Edwards. Aye. Senator Puller. Senator Obenchain. Senator McDougal. No. Senator McEachin. Senator Stewart. No. Senator Vogel. No. Senator Stanley. No. Senator Reeves. Senator Garrett. Senator Norman.
No.
7 yeas, 8 nays.
The substitute motion having been defeated, the primary motion before us is whether or not Senate Bill 439 should be reported and re-referred to Finance. Is everybody okay reversing the vote?
Sure.
Okay. All right, then if we will reverse the vote, the bill will be reported on a and re-referred to Finance. Okay, let me give you that one back. Senate Bill 612. If I could direct your attention to Senate Bill 612, which previously had been continued. Senator Black's bill dealing with the criminal history record information checks on handgun purchases. This was a bill also that had been continued until 2013 on a 14-to-1 vote. Who was the dissenter on that? Senator Obenchain was the only one that voted against continuing the bill until 2013. May I have a motion to reconsider that bill, please? Moved and seconded, Senate Bill 612 be reconsidered. All in favor, please signify by saying aye. Aye. All those opposed, and that bill is reconsidered. May I have a motion to report the bill, please? Excuse me, to continue the bill until 2013. Moved and seconded that Senate Bill 612 be continued until the 2013 session. All in favor, please signify by saying aye. Aye. All those opposed? And it is carried over until 2013 on a 14-to-1 vote. Is that it? Everybody agree? We got them all? Okay. Now, do I have a clean docket for today? Are the I appreciate very much the patience of the committee, which I certainly understand was taxed There is one bill that we're currently checking with the clerk's office on a parliamentary ruling, and as soon as I have an answer on that, I will share with you. But in the meantime, on the sign-up sheet, we have Senate Bill 626, which is Senator Peterson's bill, and this is a bill dealing with urinating in public.
Thank you, Mr. Chair. I think this bill goes from the sublime to the ridiculous, but it came to me at the request of the Carriage Park Homeowners Association, which is a townhouse community immediately adjacent to a particular university in Northern Virginia, and apparently a few of the university students, after a couple probably too many libations, have on the property of the Homeowners Association have relieved themselves. And so the head of the Homeowners Association asked me to bring a bill specifically to address this. While you all have been going about your business, I actually done a little bit of research to see what other statutes might apply in that situation. There's really two. Indecent exposure, which is 18.2-387, which has to do with indecently exposing your private parts, and then 18.2-415, which is disorderly conduct. And actually, disorderly conduct, when I talked to the HOA, was what I thought this would fall under. But in reality, disorderly conduct is slightly different. It talks about really doing something that would be more likely to cause a violent or a disruptive action. So the bottom line is, Mr. Chair, I put this in. I think it's self-explanatory. It was done at the request of a constituent group. I brought them forward. I'm bringing it forward, and I give it to you.
Well, Mr. Chairman.
Does anyone have
No, it's definitely not retroactive.
Does anyone have any questions?
I'm at
Mr. Chairman,
The
Mr.
rushing
Chairman.
water makes you do strange things. Does any member of the committee have any questions of Senator Peterson on 626?
Mr. Chairman,
Senator.
am I correct that this has been and is routinely prosecuted as indecent exposure all over the Commonwealth on a pretty regular basis? Isn't that the case?
Yeah, if I might respond, Mr. Chair.
Yes, sir.
And I think that is, the response is yes. I think there might be circumstances in which if you don't actually witness that, it may not be. I think it'd also be prosecuted as a trespass under certain circumstances. Again, as I said, I brought this out as a constituent request, and that's what I've done.
Does anyone who'd like to speak in favor of the bill? Anyone who'd like to speak against the bill? Ladies and gentlemen of the committee, Senate Bill 626 is before you.
Mr. Chair, I thank the committee.
No, this committee is not going to let bills die on the
Okay.
silence. Hearing none, I'd move that 626 be passed by for the day.
Second.
It's been moved. Is there any discussion on that? It's been moved and seconded that 626 be passed by for the day. In my position, Senator Peterson and everybody in the Senate and the House gets an opportunity to have a vote on their bill. We
I
are
appreciate that.
not letting them die by silence this year. Okay. All those in favor of 626 being passed by indefinitely, please signify by saying aye. Aye. All those opposed?
Thank you, Mr. Chair.
Thank you very much. Next, Senator Herring. Senator Herring has Senate Bill 222. If I may direct your attention to Senate Bill 222, please.
Mr. Chairman, this is the financial exploitation bill, and at your request, on Thursday morning, I convened a meeting of the various patrons that have introduced bills on this topic, Senator Stewart, Senator Vogel, representative from the administration, a representative from the Attorney General's office, from various stakeholder groups, including AARP, Alzheimer's Association, Fairfax County and its Financial Crimes Division, and probably some others. We worked diligently to address some of the concerns that had been raised last week. We have reached an agreement and think that we have the bill in good form. We discussed the bill number of Senator Stewart's bill be used as the primary vehicle, with Senator Vogel, myself, and Senator Stewart as chief co-patrons. I'm sure all of those representatives that I mentioned, perhaps some others that I overlooked, are here to express their support if you would like to hear from them.
I'm sorry, Senator Stewart, go right ahead, sir.
Thank you, Mr. Chairman. Mr. Chairman, we did work on this a good while with a lot of stakeholder groups. I actually was carrying the governor's bill, and there's a budget amendment in place with that, so we thought this was the right vehicle to go forward on. So I think all these bills would be rolled into Senate Bill 431. Mr. Chairman, what this now does, and Senator Herring, correct me if I'm wrong, this would create a new section 18.2-178.1, which is actually financial exploitation of incapacitated adults. Now, I'm doing this cautiously because I've not actually looked at the substitute, but I'm telling you what the substitute was supposed to be. When we went through, I've got it, I just haven't looked at it yet. Financial exploitation of incapacitated adults. We purposely took out elderly persons, and we purposely took out an arbitrary age because we felt someone who was 60 or 65 may be offended that could be used as a threshold for incapacity, Mr. Chairman. And it creates essentially two classes of offenses. And those classes would be any person that was taken advantage as a result of them being incapacitated as defined within the bill would be punished as a felony from 1 to 20 years. There's no minimum mandatory or anything. And the second class would be any person that is taken advantage of as a result of their incapacity as defined therein by a person who is in a position of trust, which would then be a Class 3 felony. Mr. Chairman, that is the substance of the bill, and I believe that I have represented it accurately. This is what we worked on. This is the agreement we came up with the help of a lot of hard-working folks in Senator Herring's office.
All right, let me just see if the staff attorneys have a couple of tweaks. Mr. Benjamin, my notes suggest that on line 34 that perhaps there's something problematic with the term temporarily. Is that still a concern, sir?
Mr. Chairman, what you have before you, I think, are some of the earlier concerns. I worked with this particular substitute over the weekend, and I recognize that it represents a tremendous amount of focused work by the patrons and the concerned parties. It still has some difficulties. For example, and I just mean these by example, and I know that this is the
Let's
best...
try to knock them out in my order. What
Okay.
about temporarily on 34?
I didn't like that because I didn't know what it meant, but...
Mr. Chairman, if I can respond to that
No,
before
just
we
let me
get in the
finish
weeds.
first. Okay, let me find out what the issue is first.
Okay.
Mr. Benjamin.
Yeah, that was the least of my concerns. Temporarily, I think that the problem, I'm searching my memory now, the problem that we've had with that is that there are instances where a caregiver will want and need the temporary use of a person's property for good purposes.
Mr. Chairman, if you read on line
Okay,
31...
Mr. Senator Stewart, let him finish, okay?
That's enough on that.
Okay, all right, Senator Stewart,
If
thank
you
you very
read
much.
on line 31, Mr. Chairman,
Yes, sir.
it shall be unlawful for any person to knowingly, without legal justification, and we specifically put that language in there to apply to Mr. Benjamin's concerns, so that if I have the power of attorney for someone and they are driving down the highway, swerving in and out of the road, and I know it's incumbent upon me to take that car away or license away to protect themselves or others, we have the legal justification to do it, to temporarily or permanently deprive them of that property without being prosecuted under this statute.
Mr. Chairman, my concern, let me see if I can give you an example. If a person becomes concerned that someone for whom they have responsibility is using their credit card to make ill-advised purchases, takes that credit card from them, thereby temporarily depriving them of the use of their credit card so they can't go online and make ridiculous purchases. They have temporarily deprived that person of the use of their credit card. Now we're putting them in the difficult situation of trying to figure out whether that's with or without legal justification. That seems like a simple matter for us to decide, but I think that it puts the caregiver in a very difficult position of wondering if they are technically under, if they're technically breaking the law.
Mr. Chairman, wouldn't any fiduciary be under that kind of
Okay,
scrutiny?
we're not going to get in a running debate, and I think we've got the issue teed up on it. I think the issue before the committee, let's try to knock them out one at a time if we can, Senator Stewart and Senator Herring. The first issue is whether or not the word temporarily should be deleted. What is the position of the patrons on this? And Senator Vogel, are you part of this dialogue also?
Mr. Chairman, we have no objection to eliminating temporarily. We think it's better with it in it. The bill's better with it in it. But I don't think it's that significant. I think we can strike the word temporarily on line 34, and it's not going to
I think we're swatting the gnats on the donkeys.
That's fine. Mr. Chairman, I'd move that we strike the word temporarily on line 34.
It's been moved and seconded that the word temporarily be stricken. Any discussion? All those, this is on line 34.
Actually, we should strike the or as well.
Yeah, we should strike the or also. Is it any discussion? If not, all those in favor of, on line 34 of striking temporarily and the word or, all in favor signify by saying aye. Aye. And that amendment is made. Mr. Benjamin, I think you also, my notes reflect that you had some ruminations on the definition of incapacitated. It's now an incapacitated adult.
Yes.
As opposed to an incapacitated person.
Well, here's some of my concerns. The language on line 18, for example, speaks of someone who suffers from and then describes a series of conditions. And this raises a question of whether someone, I mean, if you're a defense lawyer, you're going to ask whether someone in fact was suffering from advanced age or suffering from a disability. And this puts us into a debate that is unnecessary and potentially insulting to some people. Some people might say that they do not suffer from a disability or from advanced age. In fact, they might say that they thrive because of advanced age. But nevertheless, because of the advanced age, they are impaired in their ability to control their own resources. We also use terms in, for example, on line 19, mental retardation, I don't think is a term that we use any longer. These are terms that fall into use or disuse as professionals disagree or agree on what is more accurate descriptions of certain conditions. And so my criticism or my concern is the use of specific terms when we're trying to describe what constitutes an incapacitated adult. Spotting these and many other problems throughout the bill as it comes to us now, I wanted to suggest a concept for the patrons to consider that may achieve all or most of what they are trying to do, and in a way that exists already in the code. The crime of rape and other sexual assaults can be accomplished against a person's, exist when they are accomplished through the use of a person's physical helplessness or mental incapacity. And so it occurred to me that we may be talking about the same sort of thing, protecting a person from theft or embezzlement of their property that is accomplished through either their mental incapacity or their physical helplessness. And if the patrons agree that this is what they are seeking to do, and I think that it is, having seen these many years of their hard work on this concern, I could suggest language that makes it a crime to obtain, convert, use, control a person's property through the use of his mental incapacity or physical helplessness, and then define those two terms, similar to the way that we have defined them under the sexual assault statutes. That approach might be more workable than what we've tried to do here.
Senator Stewart, what's the reaction of you and Senator Herring and Senator Vogel?
Mr. Chairman, that's what we're trying to do, essentially, so I have no objection to pursuing that. I'd like to hear what Senator Benjamin has to say.
Senator Herring, what's your thoughts, sir?
I agree. That's the gist of it, and we want to make sure that people who have diminished capacity are protected.
Okay. Senator Vogel.
Yeah, Mr. Chair, I would agree. I think that's okay.
Mr. Benjamin, can you give me some language
I can.
in the next few minutes or now?
I can give it to you now.
Okay, if everyone would please be attentive, Mr. Benjamin is offering some alternative language as to, on line 18, what is now the definition of incapacitated.
Well, actually, this would be an entirely new
It would be
section.
an entirely new bill. I got it.
The concept would have language such as this. It shall be unlawful for any person to willfully, knowingly, and intentionally use, take, convert, or control the property of another with the intent to defraud or permanently deprive the owner of the use, benefit, of possession of his property through the use of that person's mental incapacity or physical helplessness. The next subsection would define mental incapacity as mental incapacity means that condition of the owner existing at the time of the offense which prevents the owner from understanding the nature or consequences of the use, taking, conversion, or control of his property and about which the accused knew or should have known. Physical helplessness, this would be a subsection C, means unconsciousness or any other condition existing at the time of the offense which otherwise rendered the owner physically unable to communicate an unwillingness to give, permit, authorize, or consent to the use, taking, conversion, or control of his property, and about which the accused knew or should have known. That is the concept of this.
Is that basically a replication of some language that currently exists?
It is. Physical helplessness and mental incapacity come from the sexual assault definitions at 18.2-67.10, modified to apply to the taking and use of property.
Mr. Chairman, if I might, if Mr. Benjamin could have somebody prepare that in the nature of a substitute and let me look at that and pass this by for the day. We spent so much time
Yes, sir,
analyzing in the weeds on this bill, it's virtually impossible for me to
And I couldn't agree with you more. If there could be a motion to pass this by, do we need, before I finish, do we need to pass it by for a week or until Wednesday?
We probably better do it till next Monday because we're so busy, and then we can get a substitute done and we can all get together and analyze it and see if it works. Or you want to try to do it before Wednesday?
And as I understand it, just before you all leave the dais, that we're going to take Senate Bill 285 and Senate Bill 443 and roll it into 431 with everybody being a co-chief patron.
And also 222. I have two financial exploitation bills, if you could put both of those in.
Okay.
And Mr. Chairman, probably by for the day, we'd probably get back to it on Wednesday.
Okay, that would be very nice then.
Will you?
It's been moved and seconded that Senate Bill 222 be passed by for the day. All those in favor, please signify by saying aye. Aye. And, all right.
Thank you, Mr. Chairman.
Thank you very much. Next is Senator Ruff. Thank you for waiting very patiently, sir. I'm sorry. Senator Herring, you had another bill. It was 285. 285 also. Okay. May I have a motion to pass 285 by for the day, please?
So moved.
It's moved and seconded 285 be passed by for the day. All in favor signify by saying aye. Aye. All those opposed, and that bill is passed by for the day. Senator Ruff, yes, sir.
Thank you, Mr. Chairman. Senate Bill 429, and you do have a substitute for that.
It's been moved and seconded that substitute to Senate Bill 429 be adopted. All in favor signify by saying aye. Aye. All those opposed, and the substitute is before us.
Mr. Chairman,
Senator
the goal of Senate Bill 429 is to eliminate redundant paperwork in the process of purchasing a firearm. When making a purchase, the buyer is required to fill out a federal form and a state form. Since many of the questions are the same, the bill keeps the state form focused on the information that the federal does not, such as convictions, restraining orders, mental health issues, and it adds a question about temporary detention orders. The substitute before you is in accord with the state police.
Okay. Does any member of the committee have any questions of Senator Ruff on Senate Bill 429? Does the state police have any position on this bill?
Mr. Chairman, while he's coming forward, what's the difference? Which questions are left out?
The differences are the criminal, the restraining orders, convictions, mental health issues, and it adds a question about temporary detention orders that this body passed a year or two ago that did not end up on the form as it should have.
Does that answer your question,
Well,
Senator Marsh?
What's the advantage in eliminating questions? That's what I don't understand. That.
If you're filling out two sets of paperwork asking the same questions, it seems it wasted a lot of time, not only of the people in the store and the people applying for the license, to purchase the weapon. Your race does not change from 1 minute to the next. Your sex does not change from 1 minute to the next.
But who looks, is the same scrutiny given by both agencies? Does one agency look further than the other? That's my question.
I'll let the state police address that.
Going back to my original question, do the state police have a position on this?
Senator, in answer to the questions, the checks are all done the same. The duplication is what information is captured between the two forms, and when you combine the two forms, we're still getting the same information that's needed to conduct the check. You just don't have to fill it in twice, your gender, your race, certain information. But all information goes into the check. It's just taken off of a combination of both forms.
Does the state police have a position on the bill?
We think this new language in this proposal will assist us in conducting the checks.
Okay. All right. Any further questions? Anybody who would like to be heard in favor of the bill? Anybody who would like to be heard against the bill? If not, ladies and gentlemen of the committee, Senate Bill 429 is before you. We have 1 second. We got a fiscal impact on this. Does not. No. Okay. Thank you. Is there a motion to report Senate Bill 429, which is a substitute? It's been moved and seconded that 429, an amendment in the nature of substitute, be reported. Is any discussion? Hearing none, all in favor, please signify by saying aye. Aye. And that bill is reported.
Mr. Chairman, I vote no.
Senator Marsh votes no. Thank you, Senator Marsh.
Thank you, Mr. Chairman. Senate Bill 563 deals with concealed handgun permit. It makes a few changes to the concealed carry permit application. Under B3, it addresses an exemption for transport to a shooting range. Under the same issue, it addresses in another section, adds a section about transporting to a training location. In Section D, it clarifies that the clerk of the court can only require what the state has said is required, and it allows for the permit to be mailed to the permittee applicant's permit applicant's address. There are two amendments. The first amendment would require the person to apply in person, as it is now, and the second one, under K1, an amendment to reinsert the language requiring proof of a new address if somebody has a change of address.
Is there a motion to adopt the amendment to 563? Moved and seconded that the amendment to 563 be adopted. Is there any discussion? Hearing none, all in favor, please signify by saying aye. Aye. All those opposed, and the amendment to 563 is adopted. Does any member of the committee have any questions of Senator Ruff on 563? Is there anyone who would like to speak in favor of 563? Is there anyone who would like to speak in opposition to 563? I'd ask again, do the Virginia State Police or any local law enforcement have a position on this bill?
Not going to let you get far today.
Good morning, sir.
Morning, Mr. Chairman, members of the committee. Bob Kemmler from the State Police. We think it brings in line what the actual practical applications of how people are using the permit.
Okay. All right, ladies and gentlemen, 563 is before you. Is there a motion? Been moved that 563 be reported as amended. Is there any discussion? Hearing none, all those in favor, please signify by saying aye. Aye. All those opposed? No. With the noes, please note with your hands. I'm sorry? The bill is reported 11 yeas, 4 nays. Thank you, Senator.
Thank you,
Ruff.
Mr. Chairman.
Next, Senate Fiola is, I don't see her. Pardon me? That's what I thought we took out. Senator Blevins, 314.
Thank you, Mr. Chairman. Mr. Chairman, members of the committee, I'll make some brief remarks about the bill, Senate Bill 314. As I'm sure the committee is aware, JLARC conducted a review of Virginia's system for civil commitment of sexually violent predators to the Virginia Center of Behavioral Rehabilitation and the Conditional Release Program. Of the 15 recommendations, one suggested amend the code to remove the reference to any specific actuarial risk assessment tool, the static 99, or a specific score on an instrument. Currently, Virginia is the only state with a sexually violent predator program that names the risk assessment tool in the law. The legislation removes the language about the tool and corresponding score and instead creates a 3-agency protocol process which utilizes the actuarial tool as a primary guideline to the decision process, yet allows for critical judgment and mitigating circumstances to also be considered. These agencies I refer to are the Department of Corrections, the Department of Behavioral Health, the Department of Developmental Services, and the Office of the Attorney General. The agencies vetted this language internally before the bill was submitted. Nothing will change with the steps in the current process with the Commitment Review Committee, and the Attorney General retains the final decisions on recommendations for the court. And, Mr. Chairman, we have an amendment that I would like to have passed out at this time so
Yes, sir.
that we can proceed.
And what does the amendment do, Senator Blevins?
The amendment that you have before you states that the Director, in coordination with the Office of the Attorney General and the Department, shall report biannually to the General Assembly on the protocol and the evidence-based best practices in use. The report shall disclose whether the protocol will continue to be used or if changes will be adopted, along with the reasons for the implications of the decision.
And where did that come from, Senator
And,
Blevins?
Mr. Chairman, this came as a result of trying to put the two bills between Senator Howell, which is Senate Bill 91, and this bill, Senate Bill 314, together and make an amendment in the nature of a substitute and roll her bill into this bill, which she and I have talked with. We suggested the other way. She talked to me a few minutes ago and suggested it would be done this way. She thought it would be the better way to move.
Okay. Senator Howell was kind enough to advise me that she graciously had agreed to roll her Senate Bill 91 into Senate Bill 314. The amendment is before you. May I have a motion the amendment be adopted, please? Moved and second that the amendment to Senate Bill 314, as explained by Senator Blevins, be adopted. Is there any discussion? Hearing none, all in favor signify by saying aye. Aye. All those opposed, and that amendment is adopted. Is there anyone who would like to speak in favor of Senate Bill 314? Is there anyone who would like? Is that a yes or is that a no? Is there anyone who would like to speak in opposition to Senate Bill 314? Yes, ma'am. Good morning.
Thank you, Mr. Chair, members of the committee. Mary DeVoy of Reform Sex Offender Laws. I'm not in opposition. We just have a little bit of a concern. Back on November 2011, the Associated Press did a report, an investigation, and I have copies of that determined only 73 out of 436 cases being considered for civil commitment of SPPs were completed within the 120-day window. Senator Blevin's bill does increase that by 60 days. We hope that this means the AG's office will begin the assessment process 2 months earlier than they do today and not to extend the process an additional 2 months after the term of incarceration has expired.
Yes, ma'am. I think we all aspire for that.
To do it early.
Obviously, the protocol needs to have some consideration on it. So
Definitely.
thank you for pointing that out.
Thank you very much.
Anyone else who would like to be heard? If we could have a motion to roll Senate Bill 91 into Senate Bill 314 and to list Senator Howell and Senator Blevins as co-chief patrons. Senator Benjamin.
Mr. Chairman, I questioned the reason and the meaning of the change that is reflected in the amendment. The language in the original bill at lines 102 through 107 is understandable and directs that the director, in coordination with the Attorney General and the department, develop a protocol that's consistent with best practices. And I thought that language made sense. The amendment, I really don't understand. All the amendment does now in substituting for that language is require that the director Jesse has corrected me. This does not substitute for the language. It just adds an additional requirement.
Yes, sir. I think it just
Thank
adds
you very
anything.
much.
Yes, sir. Okay. It's been moved and seconded that Senate Bill 91 be rolled into Senate Bill 314. Probably going to come out an amendment in the nature of the substitute listing Senator Howell and Senator Blevins as chief co-patrons. Is there any discussion on that motion? If not, all those in favor, please signify by saying aye. Aye. All those opposed? And that bill is reported. Thank you,
Mr.
Senator
Chairman.
Blevins. We got anybody else out there hanging around? Let's see. I got Blevins. Oh. 585. Senator Northam has Senate Bill 585, which deals with local inmates and psychiatric admissions. He has asked that that bill be passed by for the day. When we notify him of this, you may want to tell him that his bill is going to live or die at the next meeting. Is there a motion to pass 585 by for the day?
So moved.
Been moved and seconded, Senate Bill 585 at the request of the patron be passed by for the day. All those in favor signify by saying aye. Aye. All those opposed, and that bill is passed. Senator Howell, you had Senate Bill 111.
Thank you, Mr. Chairman. Senate Bill 111 establishes the program SURE, which is sanctioned with Unified Rapid Enforcement. This is an administration bill. It is the result of the Reentry Council's work, but I am very pleased to be patroning it because it's very consistent with what work that the Public Safety Subcommittee has been doing for the last several years in finance. We've been very concerned about technical violators. These are usually people who violate the conditions of their probation and then are sent to prison. We find that about 600 people a year go back to prison, half a whole prison's worth of nonviolent technical violators. we'd been researching what was going on in other states and discovered that Hawaii has a program on which this is based that has been extremely successful, because what it does is it requires, first of all, that the probation officer go to the court with a violation, and then that there is sure, quick penalty. And the penalties are laid out. It's a matter of going back to jail for a specified amount of time, with escalating amounts of time as they re-offend with technical violations. This has been worked on very hard by the administration, and I guess rather than keep talking about how enthusiastic I am about it, I'll let them answer any questions.
Well, let me demonstrate my enthusiasm, and it's been moved and seconded that the amendment in the nature of the substitute to Senate Bill 111 be adopted. Is any question? If not, all those in favor of adopting the amendment in the nature of substitute to get it appropriately before us, please signify by saying aye. Aye. All those opposed, and the amendment in the nature of the substitute is adopted, and we'll be happy to hear from whomever. Good morning.
Good morning, Mr. Chairman, members of the committee. We're, as Senator Howell said, we're very excited about this. This is actually a work product of the late Dr. Rick Kern, has been working with us for the last 8 months on this pilot. It will be piloted in up to 8 localities in Virginia. Those localities have not been identified. And the Sentencing Commission, I've got Meredith for our owns from the Sentencing Commission, will be working very closely to identify those localities. It provides, as Senator Howell said, a very swift, certain, modest sanctions for individuals who violate their probation. And I'll be happy to answer any questions on this bill.
If you'll remain there just for a moment, I'll be happy to hear from the other speakers.
I'm Meredith Farrar Owens from the Sentencing Commission. Of course, we would be more than happy to work with the Secretary's office and the Governor's office on this bill. We're very excited about trying this program here in Virginia on a pilot basis. And of course, at the end of the pilot program, there would be an extensive evaluation of the pilot project to bring back to you.
Well, I'm amusing about the fact that everybody's excited about it. I think the question is it good public policy? And so I think that's the dispositive question. Looking at my notes on it, and this is sort of the collaborative effort, is first of all, do we wish the dirty screens to be handled by the sure sanctions?
The dirty screens would be identified through the Probation and Parole Office.
Could you pull the mic a little closer?
The dirty screens would be handled by the Probation and Parole officers before the offenders are brought in before the judge, should the offender decide to participate in the sure sanction.
Mr. Benjamin, would you like to articulate on that a little bit, please, sir?
No, sir.
Okay. Thank you. 34.
I do have a question, if I may.
Yes, sir. Please.
The question for the patrons. I see on line 51 at subsection F, after a 4th violation, the court may have the defendant assessed for substance abuse problems and then provide treatment. But I also see under subsection G at line 58 that after a 4th violation, the offender is removed from the program. My questions are, number one, whether there should be a provision for substance abuse evaluation and treatment earlier than a 4th violation, and secondly, whether these two subsections are inconsistent with each other.
I think the way we worded it.
Mr. Chairman, if I may,
yes, ma'am.
Under paragraph G, it's upon completion of the sentence for the 4th subsequent violation. So he's actually going to be sentenced to that and serve his time, and then after that would be removed from the program.
And Mr. Chairman?
Yes, sir.
It's the same thing under F. It's after he has served his sentence for a 4th violation that he may then be assessed for substance abuse and provided treatment. And my question is whether holding out that possibility is inconsistent with removing him from the program, or if that is what is intended, that after the 4th he be removed from the program, but the court give him the opportunity for substance abuse evaluation.
Yes.
That's what's intended?
Yes.
Okay, then the only other, Mr. Chairman, the only other question is whether as a matter of policy, substance abuse evaluation and treatment should be offered sooner than a 4th violation. And that's...
Mr. Chairman, if I may.
You may.
In Hawaii, this program is based on something that was tried in Hawaii and has been found to be very successful. In Hawaii, they're calling it behavioral triage. In other words, you base your sanctioning and your evaluation of the offender based on his behavior under probation. So after repeated positive drug screen, so repeated technical violations for positive drug screen, the judge can then order the offender to be assessed for true substance abuse or true addiction.
How did you come up with 4?
A compromise from the governor's nonviolent offenders, Alternatives for Nonviolent Offenders Task Force.
Okay, a compromise suggests that there are other parameters. What were the parameters?
It was partially based on the evaluation from the Hawaii program, Mr. Chairman, which found that after the first 3 or 4 violations, there were so few offenders actually coming back for those. That's how effective the program was. There were so few probation violators coming back with technical violations after the 4th.
Okay. Yes, sir. Would you like to be heard on this point?
Mr. Chairman, Mike Doucette, Commonwealth Attorney for the City of Lynchburg, and I was involved as far as the planning process of this is concerned. And yes, the data suggested that the 4 was the operative number, that before 4, someone could very well just be, as Dr. Kern used to call him, a knucklehead, somebody who used drugs because they chose to use drugs but weren't necessarily addicted. The 4 was statistically relevant because that was when someone was identified as being an addict, and they were about 12% of the population that was using drugs. The thing to keep in mind as far as this particular program is concerned is that this is in conjunction with and not in lieu of drug courts. And so maybe to address one of Mr. Benjamin's concerns is that as far as screening for drug courts are concerned, that could very well take place this project would not take that out of the loop. That would still be out there. This project, though, is designed that once someone opts to, on their first technical violation, to go into the Project Sure, that they go through the Project Sure. So, and at that particular point in time, if they have not been assessed or they've been assessed and not found to be addicted, they go into Sure. But at this particular point, if they're not shown to be addicted, they go through the Project Sure, they go through their 4th violation, usually that of a dirty urine screen, at which point they are removed from Sure. Could be then, because they are now statistically relevant as far as being an addict, be reevaluated for the drug court program. The only other thing I could add to this is the question that the chair asked as far as a policy consideration, is, besides being enthusiastic, is this good policy, is that, and I remember back in college 30-some years ago and heard it reiterated by Dr. Kern, is that studies have shown over and over and over again that the way to modify people's behavior is not through the severity of the sentence, it's by the swiftness and the surety that sentence is going to come. And that's the basis behind Project Sure.
Okay. Don't leave, Mr. Benjamin.
While Mr. Doucette is there, 2 technical questions, if I may, Mr. Chairman. On line 17, my question is whether, as a condition requiring arrest, we should substitute probable cause for reasonable cause.
I raised that question over in the House. I was assured, no pun intended, that under the definitions of reasonable cause that were out there, that equated to probable cause. I was not exactly happy with that.
Well, I'm not happy with it either. So,
but I also looked, and I think we also have to look at the language of 53.1-149, which is referenced on line 18, because that sets forth the parameters for a probation officer to issue the PB-15 that brings them into custody. And it doesn't mention anything there about probable cause. But I shared Mr. Benjamin's concern about the word reasonable on line 17.
Well, preempting Mr. Benjamin a little bit, how about go over to line 34? if the court finds good cause,
And
what's that all about? Should that be probable?
Well, and again, if
Or
I recall,
preponderance?
I did not draft this, but as I recall the language in 19.2.306, I believe it is, when, and this is the existing language, and I'm sorry, Mr. Chair, I'm going by memory. Line 79, existing language of 306. As far as violations, the language is already in the code as far as good cause rather than preponderance of the evidence. So if we were to put preponderance in the evidence on line 34, that would mean that there must be a difference between a violation for Project Shore and a regular probation violation, which just requires good cause under the existing language.
I guess I'm probably just a product of being an old-timer practicing law. Good cause is sort of an amorphous term that I get probable cause, I get preponderance of the evidence, I get clear and convincing. I don't get good.
Well, good's been there for a long time, Mr. Chair. That is the existing law, and that's why on line 34 it says good cause as opposed to something else.
How about on 40?
And again, I think we're going back to line 79 as far as the existing law. It's the same standard, whether it's a probation violation or a violation of Project Shore.
Mr. Benjamin.
Mr. Doucette is correct that under existing law at 19.2-306, the current requirement is that the court find good cause, and this would cause a revocation of suspension. I doubt that anybody wants to hear this, but while this bill is before you, let me tell you that there is a practice in places in this state where Commonwealth attorneys will use a revocation proceeding in lieu of a trial on a new offense.
Sure.
So if an individual is suspected of having committed a robbery and the evidence is insufficient to get a conviction, or if the evidence is suppressed because of unconstitutional conduct, there are some prosecutors who instead will not have a trial on the new offense, but will bring a revocation proceeding, and in instances which are substantial, where defendants have 20 or 40 or lifetime suspended sentences, the individuals are susceptible to substantial incarceration on what the current law says is just good cause. My suggestion while this bill is before you is that you substitute throughout this statutory framework fines by a preponderance of the evidence in place of good cause, so that there is at least a standard that is known to the system.
Senator McDougall, before you ask a question, does the AG's office care to be heard?
Mr. Chairman, Steve Whitmer with the Attorney General's office. The good cause language in 19.2-306 has been construed by the courts to mean any cause deemed by the trial court sufficient. This is necessary to give trial judges flexibility in providing supervision over probationers, and I would suggest that if the committee adopts Mr. Benjamin's amendment, this will substantially impact the ability of trial courts to supervise offenders who are on probation and parole.
Okay, thank you very much. Senator McDougall. He passes. Okay.
Mr. Chairman.
Excuse me, Senator Stewart.
I have a couple, Mr. Chairman.
Okay.
If I may. Senator Howe, how do folks get into this? Do they volunteer to go into this? And if so, who concurs with that? Does the prosecutor have to concur that they're a good person, or probation and parole? How practically would that work?
Yes, they agree to go into it, but the Commonwealth attorney or the judge or the defense counsel can all say no.
Where does that say that? I mean, are they identified, I'm sorry, Mr. Chairman.
That's
Mr.
all right.
Chairman.
Thank you, Senator
Are
Stewart.
they identified by somebody as being a good potential candidate sought out, or do they come and try to get in it? I don't see that in the bill, and maybe I'm missing something.
Mr. Chairman, yes, if you look at 19, I guess line 85, that would be the way these individuals would participate. But essentially, the probation officer would determine, after having someone violate his or her conditions, to say this person is a good candidate for the SURE sanction. That person would then be brought in front of the judge after the first technical violation. The judge, in conjunction with the Commonwealth's attorney, would decide and give this individual an option to participate in the sanction program. But 1985 basically provides the...
But, Mr. Chairman,
Senator Stewart.
and I apologize, it says they may place them, so it's not voluntary. Because under the way this reads, they can't decline. They may be placed in it, and you've actually got, like, I've seen situations where in plea agreements they will waive Fourth or Fifth Amendment rights for certain purposes. And if I read this thing right, and I'm not saying I oppose the bill, but I want to make sure what I'm voting on here, you may place them in it without their concurrence, in fact, maybe over their objection, and you would have effectively waived their certain Fourth and Fifth Amendment rights without them actually concurring in being in this program. And the difference I see between this situation and a plea agreement is they enter into a plea agreement and they're counseled on that agreement, and the judge understands all that. Am I missing something here, or does this do what I think it does?
It's a modification of their probation, so that would not implicate the constitutional issues that you brought up. But if you look at 28, line 28, the attorney, the Commonwealth's attorney or the court may object to having the individual participate in the SURE hearing.
Well, I'm sorry, where?
Line 28.
Relations to the offender
little
absconded from
I3,
one.
the offender, the attorney for the Commonwealth or the court or the offender may object to participating in the expedited SURE hearing.
I'm sorry, Mr. Chairman, I see on line
Understood.
29 they can object to an expedited hearing.
The SURE, yes.
Where does it say they can object to being in the program?
The part of the SURE, the expedited hearing, is that once the individual decides to enter into that, options into the SURE model, part of the SURE sanction is the expedited hearing, within 48 hours, the immediate sanction. That individual can opt out from that expedited hearing once, after that first revocation hearing, he comes in front of the judge, and the judge says, you violated, I'm going to put you in the SURE program. Next time this happens to you, you do X, Y, Z. Next time you come back in front of me, I am going to put you in the SURE program. The offender agrees to that. He comes back the second time. At that point, he can certainly decide, Judge, I've changed my mind. I don't want to participate in that expedited hearing. And the judge is allowed, within that perimeter, to pursue the sanctions under 306.
Mr. Chairman, thank you. I don't see that, but I trust you when you say that, but I don't think the statute actually reads that way.
Mr. Chairman, if I may.
Yes, sir.
If I may, this House is also before, this bill is also before the House.
I'm not interested in what's before the House. I'm interested in what's before me.
I understand, sir, but what I was going to say is when it was before the House, there were a number of amendments that were offered at that time that would address Senator Stewart's concerns. Unfortunately, they're not on the website yet. I checked as late as yesterday to see if I could print them off to have those available, but there was a number of amendments made at that particular point.
Well, why don't we drop this down on the dock and see if maybe you can try to retrieve those, because I'm not a particularly scrutinizing reader, but I'm not seeing in the language either.
Mr. Chairman, may I ask one more question while
Sure.
Bancy's here?
Senator Stewart.
I do have some other concerns, but particularly I see down in the enactment clause that it creates a pilot program that you're going to do in 10 jurisdictions. But then actually the language goes on to say that it's going to become effective in every jurisdiction in 2014. And I thought it was my understanding you were developing a program to pilot throughout to see how it worked before we actually enacted it across the state.
Indeed.
Question is it going to have statewide applicability, or is it going to be a pilot program?
It is intended to be just a pilot program in up to 10 localities, and the governor has put money in the budget for that. So
Can we
the
strike
goal
that
is
language?
Pardon me?
Can we strike that language that makes it effective across the state in 2014?
Yes, we can certainly strike that language if the patron is amenable to that. Yes.
I don't want to do it if y'all don't want to. I thought it was just a pilot program, but that's not what this language says down here.
It is a pilot program, and the goal is to have the Sentencing Commission review those pilots localities and then report to the General Assembly to see if we want to make this a statewide.
Mr. Chairman, I would move that, selected by the commission, I would move that after the comma, after commission on line 102, we strike everything after that on 102 and 103 with the concurrence of the patron.
Okay, it's been moved and seconded that an amendment, excuse me, on lines 101 and 102 that to try to clarify that in fact it is a pilot program rather than having statewide applicability. Is there any discussion on that amendment? All those in favor of adopting that amendment, please signify by saying aye. Aye. All those opposed, and that amendment is adopted. Do you want us to try to pass it by for a few minutes, see if you can get those other amendments?
We might be able to fix it now.
Okay.
If it is the intention that people only be placed in this program with their consent, is that the intention? Then, Mr. Chairman, one possibility on line 15 would be to insert language between the word person and placed so that it would read, a person may be placed with his consent and the consent of the Commonwealth Attorney in the SURE program and... Yes? No? Does that do what you want?
Mr. Chairman, if I may, I think that language about the first opportunity to get into the SURE program that you're thinking of might be better placed on line 85, because that is the language that deals with the offender being placed into the program originally by the judge. The new language...
I think that's where we were focusing a little bit earlier in our discussion.
Mr. Chairman, with the consent...
One moment, please, Senator Marsh, please. Thank you, sir.
That makes sense.
Okay. All right, the substitute motion is that we insert that language that Mr. Benjamin recited over on lines 85 and 86.
That's right.
Okay. I'm sorry, Senator Marsh.
I was going to move that the language be inserted on that.
Be inserted in 85. Senator Marsh has moved and Senator Stewart seconds that the language that Mr. Benjamin recited be put on line 85 and 86. Is any discussion? Hearing none, all in favor of Senator Marsh's amendment signify by saying aye. Aye. All those opposed, and that amendment is adopted. Are we there? Is it soup?
Mr. Chairman.
Senator Stewart.
I apologize. I have one more question that...
One more question.
And this really is to Mike with the Commonwealth Attorneys Association. There was a bill recently, and I think it was carried by Senator Obenshain, which amended certain provisions with regard to bail. And specifically, it put Commonwealth's attorneys, which I think is right, on notice before any bail hearing could be had. And essentially, you had no concerns that you could get in a reasonable amount of time to get people bail hearings. But now the folks that are in this program are now giving precedence on the docket when that PB-15, and I'm using old terms, PB-15 is issued and they're brought before the court, they've got to be heard. I guess, do you have concerns that you all are now bringing so many things before that have precedence on the docket that we're actually eliminating the precedence on the docket? That worries me a little bit, and I would really like to hear you address that.
The short answer is no, and the reason it's no is because the pilot projects that are are going to be chosen with their own consent. They're going to realize what the requirements are as far as this program is concerned. And it's going to require cooperation between the Commonwealth attorneys as well as defense bar, whether it's a public defender or court-appointed attorneys, to have someone available on an expedited basis. So everybody's going to have to agree up front for that to happen. For those jurisdictions for the larger jurisdictions where this is going to happen on a much more frequent basis, they're going to have court all the time. In fact, they'll have probably multiple courts going on, and so they'll be able to deal with this, whether it's precedence or priority or whatever you want to call it. For the smaller jurisdictions, it's just not going to come up on that frequent a basis. It may come up today, and it may not come up until next week, sort of thing. But it should never. We shouldn't have clashing priorities or precedences, and if we do, it's going to be on a very rare occasion, and we're going to be able to work it out between the court and the defense bar. We're talking a matter of 15, 20, 30 minutes. We're not talking days and days and days.
All right, ladies and gentlemen of the committee.
Mr. Chairman, I have a question.
Senator Edwards, yes, sir.
I'm sorry, I've missed a lot of this.
That's quite all right.
But what's this on paragraph line 15? A person placed in the SURE program should be frequently reviewed. What does that mean? What is frequent? Daily, monthly, yearly? There's no definition there.
Well, and that's a good question. We came up with that because we couldn't come up with anything better. But I think our expectation is that the probation and parole officer would scrutinize individuals under the SURE program much more closely than they would just another nonviolent offender, because these individuals will be tested more regularly for use of drugs. They would have an intensive supervision, because the idea is to bring them before the judges immediately upon violation of their...
Well, Mr. Chairman, I guess
Senator Edwards.
I'm going to apologize for missing
right.
so much of this. But what's the point? I mean, who are these people? They're nonviolent. They're probationers. Why should they give sort of special? Why are they given special treatment? What's unique about them?
Well, on a yearly basis with the Virginia Department of Correction, we get about 600 or so nonviolent technical offenders that miss their employment appointment, their drug testing, and they party Friday night, and they see a drug and they decide to use it. We're talking about individuals who regularly violate their condition of probation, and we want to be able to
Mr. Chairman, we're talking about technical violations?
Yes.
Because, Mr. Chairman, because I get a lot of complaints, and I've heard a lot of complaints about people being put away for a long time over and over again, but for technical violations where there's not necessarily a violation of the law.
Essentially what this law...
It's violation in terms of
Senator
probation.
Mr. Chair, essentially what this bill would do is for those who are technical violators, it's an alternative to rather than putting them in jail or bringing them back to prison, is to sort of shock their behavior and change their behavior by imposing an immediate, swift sanction so that they know if they violate that condition, the next time this happens, they will be sitting in jail. The goal is to reduce that number and to reduce their behavior or change their behavior. And I think, Meredith, you can talk about...
Mr. Chairman,
Senator Edwards.
Has this been, any other states done something like this, and how does it work?
Senator Edwards, we went through the history of it while you were out here.
I apologize
how this is
for not
based
being
on
here.
The Hawaii experience. And I believe that's what you all said. Is that
Yes,
correct?
sir.
And that's been used as sort of the basis.
Mr.
Senator
Chairman,
Edwards.
has the Sentencing Commission looked at this, and
The
what's their
Sentencing
recommendation?
Commission has been working on it, and that's why they are here.
Okay.
Yes, sir.
This
All right.
attractive young lady at the dais
Okay.
there is from the Sentencing
Okay,
Commission.
thank you.
Yes, sir. Thank you. Senator Marsh, did you have...
No, I was going to say
Okay.
that the Sentencing Commission, and I'm a member, looked at this very carefully before it
Yes, sir.
recommended.
Ladies and gentlemen of the committee, Senate Bill 111, an amendment in the nature of a substitute which has been amended, is before you, and the appropriate motion would be to report and re-refer it to Finance.
So moved.
I think there was one amendment that the chair might have wanted on line 17 to change
All right,
reasonable
put it in
to
reverse and
probable.
back up. What do we got?
Line 17 has reasonable cause, and there was some sentiment that maybe that should be probable cause.
Mr. Chairman,
Senator Howell.
I've been here a long time, and as people used to say, if that's your concern, get your own bill. This is existing.
Don't get snippy here this morning.
But it's true. This is a carefully vetted bill. We're happy to make amendments to the concept here But to change the whole system on probation, I
No,
think
this
is
is not-
way beyond.
Wait a minute, no,
To
running
change the reasonable cause is just beyond what we want to do here. If somebody would like to do that, there are lots of opportunities.
Mr. Chairman, I apologize if I was misunderstood. This is not what I was talking about earlier. This is on line 17, substituting a requirement that there be probable cause for an arrest rather than the language reasonable cause, and I don't think anyone had any real concern about that. This is not a change to the
That's
probationary
as
system.
it relates to the arrest.
That's correct.
Okay.
I move that amendment.
apologize.
That's
Mr.
great, all
Chair.
right.
I move the amendment.
Everybody's getting a little testy here, and I can understand it. I've started the meeting off that would try the patience of even Senator Howell. It's been moved and seconded on line 17 that reasonable be stricken and that the word probable will be inserted. Is there any discussion? Hearing none, all in favor of that amendment, please signify by saying aye. Aye. Now, once again, I will accept a motion that Senate Bill 111, amendment in the nature of a substitute with multiple amendments, be reported
moved.
and re-referred to finance. Is there a second?
Second.
Is there any discussion on the motion? Hearing none, all in favor of reporting Senate Bill 111, amendment in the nature of a substitute with multiple amendments and re-referred to finance, signify by saying aye. Aye. All those opposed? If the noes would please signify, please, so that the clerk may. You got them all? 14, the bill is reported and referred for 14-1. Thank you all very much for your participation. We appreciate it very much. Senator, excuse me, Senator McEachin, you had Bill 655, sir. I'm sorry, I didn't hear you, sir.
I'm sorry, Mr. Chairman. To get the bill in proper form, I'd like to add the emergency clause.
Okay, it's been moved and seconded that an emergency clause be added on line 39 of Senate Bill 655. All those in favor of adopting the emergency clause, please signify by saying aye.
Aye.
All those opposed. And Senate Bill 655 is before us as amended. Senator McEachin.
Thank you, Mr. Chairman. This is one of a number of bills that will be floating through the General Assembly to deal with the Thomas Hainsworth situation. Specifically, Mr. Chairman, what this bill would do is to remove the limitation for 20 years of compensation. That's all the bill does. It seems to me, I'm not quite sure why we put 20 years in there to begin with. He's been incarcerated for 27 years. I've been told, and I will say informally, by the Attorney General, because this was just a phone conversation that we had, and I don't want to lock him into this position, but during a phone conversation, he also noted that to receive compensation under this section, one waives one's tort action. So if you leave it the way it is, Mr. Hainsworth would still have a tort action for 7 years of incarceration. Because you wouldn't be compensating him for the full amount. It's my hope that that's the bill, and I would hope that the committee would pass it.
Just an editorial from the chair. We in fact have a claims subcommittee on finance, and this bill is going to have to go there. And certainly from the fiscal perspective, that's going to be part of the policy decision as well. So I think perhaps the appropriate motion would be to report the bill with re-refer to finance with Senator McEachin, the understanding that subcommittee would be looking at this. And I would further say, I just know from parenthetical comments with that chairman that that is an issue before them right now as a result of a couple of these claims bills.
Yes, sir.
So moved.
Senator Sasslaw.
To speak briefly to the motion. I'm on that subcommittee. I think it's chaired by Senator Newman. I'm not sure. But anyway, this, when we go from, when we remove the 20-year cap, I think it increases it from about 800,000 to 1.1 million. But I got to tell you, after what I heard on the news and saw the other day, we're getting off light. a federal jury in New Mexico decided on a case where a guy was picked up.
The country, Mexico?
New Mexico was picked up in the state for drunk driving, and apparently had some mental problems. He spent 2 years in solitary confinement in a local jail before they finally, I guess family members or somebody finally got him freed. The jury awarded him $22 million, and that's for 2 years, not 27.
Thank you for sharing that. I hope that word doesn't get out.
Mr. Chairman.
I'm sorry.
Move to
Move to report and re-refer to finance.
Thank you. It's been moved and seconded that Senate Bill 655 as amended be reported and re-referred to finance. All in favor, please signify by saying aye.
Aye.
Aye. All those opposed. Thank you very much, Senator McEachin. Senator Sasslaw, you had Senate Bill 503, sir. Hmm. .503, Senator Sasslaw.
Yeah. Mr. Chairman, 503 is part of the, I guess, the government reorganization's recommendation. What they're doing, I mean, it looks like a whole lot of new language and on the Metro tax. Essentially, what we're doing is they had recommended you take it from the Department of Taxation that currently collects the Metro tax, and I'll give you just a brief history on that, and transfer it to DMV. So doesn't create a new tax, doesn't increase the tax, it just transfers where it gets collected. The Metro tax, which is mostly all in Northern Virginia, I think it now extends as far south as Spotsylvania, I think has it now, is that correct? That was started in 1980. Governor Dalton signed that in, and it was going to be 2% the first 2 years, and then after 2 years go to 4%. Warren Stambaugh, who was in the House of Delegates then, put in a bill, and that kept it at 2, where it's been ever since. The tax was collected by the dealers, and one of the problems that you had was there were 1,500 dealers and 2 people in the Department of Taxation to audit them.
Senator Sasslaw, if I could focus you, I don't think that there probably are any issues with the policy issue, but if you go over to line 244, as you read the bill, there are a series of civil penalties for late filing, but starting on line 244 are prohibited acts criminal penalties.
Which is why they sent it here from Finance. And I don't know if anybody's here from the Department of Taxation. I'm not sure that the penalties were, I don't know, if I'd have to go back and look whether they were that severe in the existing statute. And I can let it go by for,
it appears that it's creating some class 6 felonies,
right.
But the fiscal impact statement has assessed the minimal assessment that we have of $50,000 on it, and it seems that this has taken a circuitous route, that it's come from Finance to us, and that if it has a fiscal impact, then it should go back up there, which is beginning to border on an absurdity with me. But yes, ma'am, we'd love to hear from you. Step right up there. Yes, ma'am.
I'm Jim Hughes with the Department of Taxation, and just as the senator said, this bill would transfer the tax from the Department of Taxation to the Department of Motor Vehicles. And one issue is that the Department of Taxation does have civil penalties. They're not set forth in the code, except for in the specific section for the tax. We have civil penalties and criminal penalties for taxes administered by the Department of Taxation in the general section. The Department of Motor Vehicles is here to kind of explain, but this basically would mirror the penalties that the Department of Motor Vehicles has for the fuels tax.
Thank you very much, ma'am. I appreciate it.
Let me just say this. What happened was it was the dollar sales or gas sales were being
Okay,
grossly.
once again, I don't think the issue is the policy.
I know that,
on
but
it.
this
I
may
think it's
this may explain some
the
of this.
criminal aspect of it.
They were being vastly underreported.
Okay.
So I switched the collection from the individual retailer to the jobber distributor, and there's only two major oil companies left that direct deliver. One is Sunoco and one is Hess, who deliver in Northern Virginia. All the rest of the stations in Northern Virginia are supplied by jobbers, or jobbers/distributors. Since the penalties were never enforced, essentially on the when it was being collected by the retailers, and quite frankly, the jobber distributors are doing their job, and are reporting and paying all of it because the revenues jumped dramatically after they started collecting it, because you have two auditors now for 9 or 10 people, versus 2 for 1,500. So the two things that will have changed in the last 2 years, Senator Norman, are the switch to the jobbers and the oil companies collecting it, and B, shifting it over to DMV. Now, some of these penalties were there, whether they were felonies. If you want, I can go check. But that's essentially the thrust of the bill. The cost of collecting it and doing was probably the same at taxation as it's going to be at DMV, and that's I guess that's the $50,000.
Does any member of the committee have any questions of Senator Sasslaw? Senator Edwards.
Why are we shifting it from tax to DMV?
Good question. Nobody ever, they just figured that was a better place for it to be. Didn't much matter to me, or probably even to jobber distributors.
Well,
since,
the question
they got to send the checks.
Yeah, but it seems to me tax has the expertise of this is what they do. I'm not aware of DMV collecting taxes of any sorts, are they?
Well, they collect an awful lot of fees. I can tell you that. They're not babes in the woods when it comes to collecting money.
Yes, ma'am. Would you have something you would like to add that might be helpful to us?
Yes, sir, Mr. Chairman. Rena Hussey with the DMV. DMV is responsible for the collection of the fuels tax for the Commonwealth, and that is quite a bit of money. So the Government Reform Commission recommended this. Both tax and DMV have looked at it. We feel that we can more efficiently administer this tax, and we can do it with less resources than taxation and put a little more automation toward the picture. So we do feel that it's a good and efficient transition.
Senator Edwards, does that answer your question?
Thank you.
Anyone else have any questions?
Mr. Chairman.
Senator Stewart, yes, sir.
The representative from DMV or whomever can answer this question, do we typically make it a Class 6 felony if someone does not remit these taxes? And I don't know the answer to that, and that's my only concern in this bill. There are 6 or so instances where I assume a motor vehicle dealer could be prosecuted for a felony for failing to remit the taxes, if I'm reading this right? That typically done? Okay.
Mr. Chairman, I can speak to that if you would like for me to.
I spoke to it.
Okay.
I did. I happen to know a little bit about the motor vehicle business, and have been on the receiving end of that kiss from DMV. No, my clients have, excuse me, not me. All right, Senate Bill 503 is before us, and I would just say, Senator Sasslaw, we need to stop this circus. It's come from finance down to here, and I see no reason to send it back to finance. They've had the opportunity to bless it one time, so I think the appropriate motion, if the committee is so inclined, would be to report the bill.
I'll move that, Mr. Chairman.
Been moved and seconded that Senate Bill 503 be reported. Is there any discussion? Hearing none, all those in favor, please signify by saying aye. Aye. Senator Stanley, 66. Good for business, though. Senator Stanley, 66.
Thank you, Mr. Chairman, members of the committee.
Senate Bill 66 is attempting to amend Virginia Code 18.2 371.1 to add in subsection B, any parent, guardian, or other person responsible for the care of a child under the age of 12 who, with intent to conceal the fact that the child is missing, fails to report or cause report to a local law enforcement agency that the child is missing within the 12-hour period of the discovery of that fact. Mr. Chairman, I think it's been termed as Kaylee's Law. I was asked to carry this by my constituents who believe it important, and especially what we know to be a moral duty, as is now codified here in this bill, sometimes should be codified as a legal duty in this instance. I've also looked, Mr. Chairman, at other bills to see if there were other areas where this would be covered, and Mr. Chairman, I would submit that it's not, and I was given a piece of paper with regard to other existing law that codifies or may have some impact on this bill. I am not satisfied that any law addresses this very fact. As we all know, within the first 24 hours, the most important time to find missing persons. This bill deals directly with children who go missing within that period of time, and the parents, guardians, or those who are in charge of the care of the children are aware of them missing and fails to report it. So, with the pleasure of the committee, I'd move that this bill be supported.
Mr. Chairman, I have a question. Mr. Chairman? Yeah. Don't we already have a law about making false reports to law enforcement?
We do.
So this...
But this is... Oh.
How does this differ?
Mr. Chairman, I would advise Senator Edwards that we do have laws that affect failure to, or making false reports. What this bill does is directly, it's for failure to report a child missing. If the child is missing, as on line 26, fails to report or cause to report it to the local law enforcement agency, a non-statement, Senator Edwards, I would submit, is not making a false report.
Right.
So in that instance, it is different.
So, but, Mr. Chairman, I just
Senator
noticed that, I don't have the bill in front of me, except the summary says, number 1, false reports to law enforcement. If that's already covered, it's number 2, fails to report. That's what this bill does.
Yes. In fact, fails to report or cause to be reported is the exact language in line 26 of the bill.
Yeah. Mr. Chairman.
Now, in the upper part of the bill, Mr. Edwards,
Go ahead, Senator
line
Stanley.
16 does address falsely report.
Okay.
But the main thrust of the bill is failing to report.
Mr. Chairman, is Nancy Grace going to testify?
I have not called her. I would advise, Mr. Chairman, if that is a serious question from Senator Edwards, that I have not called that witness.
Any further questions of the patron?
Mr. Chairman.
Senator Stewart.
Senator Stanley, isn't paragraph A, wouldn't that fall under obstruction of justice essentially, except it heightens it to a Class 6 felony from a Class 1 misdemeanor?
Mr. Chairman?
Isn't that what we're
Senator
doing?
Stanley?
We're just creating a new form of obstruction of justice and making it a felony? Couldn't you just do that in obstruction of justice and add a section in that said it's a felony if a parent does it with regard to a child versus here?
Mr. Chairman, I would advise Senator Stewart, in response to his question, that I would agree that obstruction of justice is probably a more generalized, where this drills down and is more specific on making a false report for the care of a child, false reports circumstances of an accident or occurrence, and raises it to a Class 6 felony. We do have some of that, actually, to Senator Stewart, in 18.2 371.1, which is abuse and neglect of a child. So I would agree that those two could live in harmony, and I'm not so wedded to the first part of this bill and what it seeks to amend in 18.3 371.1, that is lines 16, 15, 16, 17, 18. However, I believe under subsection B, that is truly the thrust. The necessity and the requirement of someone who has responsibility over a child to report them missing when the age is 12 or younger, when they know them to be missing.
Mr. Chairman.
Senator Stewart.
Here's my question. Maybe I should have phrased it a different way. Aren't you now limiting the Commonwealth to proceeding with only one charge against an individual who does this, where before they could have proceeded with an obstruction of justice charge on the one hand and then and I can't recall the specific criminal code section, which is a felony when you allow them to get injured. It's not negligence, and I apologize. It's child abuse. It's a fashion of that, but there's a
371.
specific felony on that, and it's not in this section. You actually now have limited the Commonwealth to one charge here, whereas before they could have proceeded against two. And I apologize, I can't call that other section, but I think that is what's happening here.
Mr. Chairman, I would
Senator
I
Stanley.
would say to Senator Stewart that is not the intention of the bill, and I don't believe it limits the state from one to the other.
I can't think of the section, Mr. Chairman, I apologize, but maybe Mr. Benjamin
Mr.
can
Chairman,
help me.
Just a moment, please. Senator, Jesse, you're furrowing your brow. Is there
If we're looking under abuse and neglect of children, 18.2371.
everybody's flipping through the code. Senator Stanley, do you have any major objection if we pass this by till Wednesday to take a look at that?
I have none whatsoever. I just try to make sure all my bills come forward here and not requested to pass by. But if you want that, Mr. Chairman, I'm certainly for it in this one instance, so long as it does not become a habit. I've been lectured by the chairman on passing by bills. I do
Well,
not want to
you're the
know
only
who's doing
person
it.
in the General Assembly that listens to me.
No
so
objection.
I love you, sir. How about 419? Without objection, is a motion to pass it by for the day. Been moved and seconded, Senate Bill 66 be passed by for the day with the expectation that we will deal with it on Wednesday.
Thank you, Mr. Chairman.
419, sir.
Mr. Chairman, Senate Bill 419 is Governor McDonald's legislation, crime legislation with regard to this session. This legislation amends subsection B of 16.1-269.1 of the Code of Virginia by adding a second or subsequent act of violence, as defined in 19.2, 297.1 of the Code, to the list of offenses for which a juvenile aged 14 years or older will be mandated to be certified as an adult to stand trial in circuit court. The proposed legislation also has a secondary effect. It amends subsection C of 16.1-269.1 of the Code to add a list of to the list of offenses that the Commonwealth Attorney may make a request that the juvenile be certified to stand trial as an adult in circuit court under those prosecutorial discretionary certification or waivers list. These certain other felonies from this bill here include gang participation in violation of 18.2, 46.2, felonious gang recruitment in violation of 18.2, 46.3, second subsequent violation of manufacturing, selling, distributing a controlled substance under 248, a second subsequent violation of selling, giving, distributing methamphetamine, felony violation for possessing with the intent to distribute, giving, selling, or distributing marijuana, if previously adjudicated delinquent under that section, and a felony violation of manufacturing, selling, giving, distributing, or possessing anabolic steroids. So that's the main thrust of the bill.
Mr. Chairman?
Senator McEachin, yes, sir.
Senator Stanley, is it not the case that juveniles who commit those offenses can already be tried as an adult?
The ones that I've just listed, gang participation in violation, these are adding second subsequent offense.
Let me clarify my question, if I might, Mr.
Senator
Chairman.
McEachin, yes, sir. Thank you, sir.
It's my understanding that what your bill does is it removes the judge from deciding whether or not these children get certified as adults. Is that not the case?
There is a procedure in which that occurs. Mr. Chairman, I would answer Senator McEachin by also saying, well, right now this gives the prosecutors the discretion, the ability to certify and seek transfer to the circuit court and tried as an adult, not just through the judicial process.
Further question, Mr. Chairman?
Senator McEachin, yes, sir.
Can we agree that this process that you're setting up removes the judge from the equation? And if we can agree on that, why should we do that?
Mr. Chairman,
Senator Stanley.
I would submit to the good Senator McEachin that it in fact does take the judge out of the process. In this case, The judge is the arbiter of the facts. However, the prosecutor has the discretion to determine, based on facts as brought to him by law enforcement, witnesses, and other things, the ability to make those determinations, to ask that they be transferred, and then the judge to be the final arbiter of that.
Thank you, Mr. Chairman.
Yeah. Ma'am, would you like to be heard, please?
Yes, sir. Senator Norman, members of the committee, Janet Van Kirk with the Department of Juvenile Justice. This is an administration bill. The administration strongly supports the policy behind this bill. Gang and drug issues continue to be a serious issue throughout the Commonwealth.
Can you answer Senator McEachin's question?
Yes, the basic question is, does this change the pool of offenses which can be transferred or certified or waived to circuit court? The answer to that is no. As of the law today, any felony for a juvenile 14 years of age or older may be transferred, certified, or waived to circuit court. The issue here is into which category the offenses fall. In 16.1, 269.1, there are three ways by which a juvenile's 14 years of age or older's case can go to circuit court. The first is the mandatory certification. This applies to murder and aggravated malicious wounding. The bill would add second or subsequent acts of violence to that category. Some of the second and subsequent acts of violence currently fall within the prosecutorial discretionary category, and others fall within the traditional transfer process, which requires a hearing in circuit court, in juvenile court, and then the judge makes the determination. The second implication of this bill is the addition of offenses to the prosecutorial waiver category, and these are gang offenses and second and subsequent distribution offenses for Schedule I substances and the other materials detailed by the patron.
Mr. Chairman?
Senator McEachin's question about the policy issue of taking the judge out of the loop. Do you have an answer that may give Senator McEachin some comfort on that?
The assistant Commonwealth attorney, the Commonwealth attorney is the chief law enforcement officer for the locality. They have the discretion in the proposed amendment to transfer the cases or certify the cases up. This would be expediting the process. Right now in juvenile court, the hearing is held, then the judge makes the determination, it can be appealed, and then to circuit court, and there's a second hearing in the circuit court. This would allow a more expedited process for the second and subsequent drug offenders as well as serious gang members.
So is that the answer to the policy question, that it results in an expedited hearing?
And it's setting the tone in the Commonwealth against second and subsequent drug offenders and gang members.
Senator McEachin, I didn't mean to preempt you, sir.
No, I appreciate it, Mr. Chairman. I appreciate your help, and I appreciate the answer. I guess my question for the witness would be, is there any empirical evidence that you can show us where these egregious cases are not being certified as for people being tried as an adult? I mean, I guess what I'm struggling with is, what is the problem that exists, not in theory, but the problem that actually exists with our constituents that you're trying to fix?
Unfortunately, the Crime Commission studied juvenile transfer for 4 years and found habitually that there was difficulty in finding absolute data relating to what cases are being transferred and certified. This is a policy decisions based on the implications of increased drug crime and gangs in the Commonwealth.
Mr. Chairman.
Mr. Chairman.
Senator McEachin, does that complete your question, sir?
I'm sorry to test your patience, Mr. Chairman, but I just have one last question. Is there any empirical data to show that these crimes are going up? Because my impression, at least, is that most crimes are going down.
Your impression is based in fact. Juvenile intakes throughout the Commonwealth are going down, as well as commitments to the state. This is looking at a small subsection of crimes. We did pull the data for juvenile petitioned intakes on these offenses. The impact would be for the offenses going into the mandatory section, about 250 cases, and for the offenses moving into the prosecutorial discretion, about 250 cases. Looking at that relating to the overall intakes in the Commonwealth, it's about 3.3%.
Thank you, Mr. Chairman.
You're welcome. Senator Stewart.
Thank you, Mr. Chairman. I'm very curious because this is a very substantial policy move when you're talking about children. And I'm going to ask it a little bit differently than Senator McEachin did, because I quite frankly haven't gotten why I should vote for this. Why do we need to take the judge's discretion out of this role? Can you tell us where judges have been not certifying these cases? Because they can already do this anyway. What this bill does is it mandates that a judge try them as an adult as opposed to giving them the option to do it. And can you tell me why we need to mandate judges to try kids as adults in certain offenses when the judges can do it anyway? Are they not doing it when they should be? I haven't seen that, and I've been at this for 20 years.
I'm going to pass. I'm a criminal defense attorney, so you're asking the wrong guy on this one, but I'm going to let this office talk to it.
Mr. Chair, Senator Stewart, we are, in the mandated cases, we are looking at second or subsequent acts of violence. And there is a different perspective in juvenile court as in circuit court. We are not saying
Is
that
it
these...
assault and battery a subsequent act of violence?
Yeah, this applies only to felonious acts of violence defined in 19.297.1. I have a list if you wanted me to...
No, please don't share the list with me. I'm sorry, Senator Edwards, did you have a question, sir?
Yes, I did. Would you agree that the adult system is really not set up for juveniles, that we have a juvenile system because they are juveniles?
Mr. Chair, Senator Edwards, this bill deals with where the case will be held, whether the juvenile court will hear the case at the circuit court. A sentencing disposition or sentencing option in circuit court continues to be a juvenile disposition. So that remains on the sentencing options for the circuit court. The change here would be that in addition to the juvenile disposition option, you can also sentence as an adult, but that is not mandated under this bill. The bill changes where the case is heard. It doesn't change whether or not a juvenile disposition may be imposed.
Mr. Chairman, do you agree that the number of juvenile crimes is actually declining in Virginia?
Senator Edwards, we just addressed that issue, and she acknowledged that they are going down in response to Senator McEachin's question. Do you have a new question?
Yes. With regard to the subset that you're talking about, could you discuss what is this subset? Is that going up? And what is the subset? And why is it necessary to have these children being prosecuted in adult court? The subset. I think that's your argument, right?
Her argument was that it's going to expedite the process.
Let me ask you this. Is there I thought you said something about a subset that you wanted to clamp down on. What is there, or maybe I misunderstood you? There's no subset.
Yes, ma'am. Go right ahead.
Mr. Chair, Senator Edwards, the subset are repeat criminals, repeat juveniles who have committed a second or subsequent act of violence, so a violent act with a victim, and repeat drug offenders, second or subsequent drug distribution, not possession, drug distribution, and gang members. And what we are looking at, in addition to the expediting of the process, is making sure that there's a clear, consistent policy message throughout the Commonwealth on these three classes of individuals. We're focusing on the victims here to ensure that there are no subsequent victims relating to these classes of crimes.
Well, Mr. Chairman, there's been no change then in the numbers or rates or anything regarding the subset of repeat offenders, is there?
Mr. Chair, Senator Edwards, looking at the data, it's about 250 was the average over the three-year average. Last year, there were less than there were in the two subsequent years.
Okay. Ma'am, did you have something you would like to add for the committee, please?
I do.
Good morning.
My name is Labravia Jenkins. I'm the Commonwealth's attorney in the city of Fredericksburg, and I'm representing the Virginia Association of Commonwealth's Attorneys.
Good morning. Nice to have you with us, ma'am.
Good morning. We, of course, support this bill. And I guess I'd just begin by saying that it's a bill about recidivism. And children, juveniles, need to be as accountable as adults when we talk about...
Can you help us really on the policy issue that we're sort of bannering around? And that is about taking the judge out of the process?
Mr. Chairman, in response to Senator Stewart's question, I disagree. We are not taking the decision out of the hands of the judge. The juvenile court judge has a decision to make about probable cause, has a decision to make about the number of offenses that the person has previously been convicted of. And finally, as was pointed out earlier, the circuit court judge does have the ability to treat a juvenile as a juvenile or impose an adult sentence. So the discretion is not being taken away from the judge, with all due respect.
Tommy.
Thank you very much, ma'am. We appreciate very much
Mr. Chairman,
you being here. Senator Marsh, yes, sir.
in looking at the effects of this bill, it does take the discretion away from the judge. If the prosecutor has unbridled decision, the prosecutor makes the decision before it gets to the judge. That's the way I understand this bill.
The juvenile court judge hears a preliminary hearing.
Excuse me, can you respond to that? Doesn't this bill permit the prosecutors to make the decision? It takes it out of the hands of the judge, doesn't it?
Mr. Chairman, just as the violent crimes are brought to a juvenile court judge for the purpose of a preliminary hearing, these recidivist offenses will be brought to the juvenile court judge for a preliminary hearing. However, the judge still has the ability to certify to the circuit court or not, obviously, and the circuit court still has all of the abilities of the circuit court and the juvenile court after hearing the case.
Thank you very much, ma'am. We appreciate it. Is there anyone else who has not spoken who would like to speak in favor of the bill? Let's move along very timely. Come along, come along, come along.
I wouldn't like to speak in favor, Your Honor.
In favor?
Yes. No, I would not. I'd like
Okay,
to
anyone who would
oppose the
like
bill.
to speak in favor of the bill? Okay. Anyone who would like to speak against it?
Good morning, Mr. Chairman, members of the committee. My name is Julie McConnell. I'm a law professor at the University of Richmond. I take law students into juvenile court to represent children charged with acts of delinquency. But prior to that, for 6 years, I was a juvenile court prosecutor in the city of Richmond. So I'm here to answer some of the questions that you had about the judge's role, the prosecutor's role, and whether there's a problem. And
How will I help you? Based upon your analysis of it, does it take the judge out of the process?
It does, Your Honor. Absolutely.
I'm not Your Honor. I never will be.
Excuse me. I'm used to saying Your Honor. I apologize. It does, Mr. Chairman. It does take the juvenile court judge out of the decision completely, with the exception of they have still the probable cause hearing. Okay. What I would like to say to the committee is
beyond what's been described, do you think it's created a larger universal pool?
A larger pool of children that will go to circuit court. Absolutely, yes. But on the other hand, there are many cases that are tried in circuit court every year, and that should be, and judges are making these decisions appropriately. I cannot think of a single case in my entire 6 years as a prosecutor, or in my time as a public defender before that representing children, that I had a case that should have gone to circuit court and didn't. These judges are making the right decisions. You have a very extensive list of factors these judges have to consider. Under 16.1 to 69.1, they are properly considering those factors, and they're transferring the children that need to be transferred to circuit court. I just don't see that this is something that needs to be fixed. This is actually a system that's working very well. If you do this, you're going to cost the Commonwealth a lot more money, because these children will actually, it's not going to expedite the process. It's going to slow it down. It will take them longer, because we'll send them to circuit court. They'll have to wait longer for a trial. They'll be held in detention that entire time. There's going to be a major fiscal impact as a result of that. And I'll also tell you that under the factors that the judge has to consider, they consider prior record already. And so if we have an offender who has a prior possession with intent to distribute, they're going to know that, and they're going to take that into consideration, and likely will make the decision to transfer if they think it's appropriate under all the other factors as well. So it's already something the courts are looking at. It's not something that needs to be changed. There are already appropriate crimes under the intent to certify section for all the violent crimes. Those are already in the prosecutor's discretion. This is a well-thought-out statute that you spent a lot of time on. It doesn't need to be changed at this point, because there isn't a problem.
Thank you very much for joining us from the University of Richmond. We appreciate it.
Thank you very much.
Yes, sir. Somebody, let's go.
My name is Barry Green. I'm a former director of Department of Juvenile Justice, former
You like
deputy.
this bill, Barry?
No.
Why?
Several reasons. One is I think it's going to do the opposite of what is intended. I believe very sincerely that the bill is put in to improve public safety, to deal with kids who otherwise would not be dealt with well. If you take a look at the numbers right now of those who are sent to circuit court to be tried, you look at what The transfer is based on the charge, not on what the ultimate conviction is. Some convictions or pleas in the end would not have even resulted in a transfer. If you take a look at what circuit court judges are doing after conviction, a 10-year number, this is from the Crime Commission, about 5,500 kids who are transferred to circuit court. 46% of those kids end up receiving a Department of Corrections sentence. 26% get a jail sentence or adult probation. Jail sentence often is time served or a 30 or 60 or 90-day sentence. 18% are sent back directly to juvenile justice. 7% are given a juvenile justice probation sentence only. If they are in DOC, the question came up about treatment. I don't believe they get the treatment there, but the ones going to the Department of Corrections may be the ones who should be and would be transferred anyway. Those who are going to jail or onto adult probation probably would have spent more time in the Department of Juvenile Justice, but they would have gotten treatment. If you take a look, the question came up about recidivism. If you take a look at recidivism, the Department of Corrections measures it the way that adult correction systems measure it. This is a couple of years ago. I don't think the numbers have changed very much. Folks who get out of prison, who are reincarcerated in prison after 3 years, it was 28%. On the juvenile side, we took a look when I was still director. We went back 3 years, how many kids were released that ended up having a DOC sentence, and it was 3.1%. I mean, there's a considerable difference.
You're dazzling me with way too many figures. Does it, or does it not, in your opinion, take the judge's discretion out of the
It takes the judge's
process?
discretion out, and I have to say the juvenile judge has much more information in looking at whether or not to transfer than the prosecutor does in making that decision. They have a social history, they have a psychological, they have a transfer report. All you have otherwise is the police investigative report and the charge.
All right. Thank you very much. We appreciate it. Yes, sir.
Good morning, members of the committee. My name is Andrew Block, and I'm the director of the Child Advocacy Clinic at the University of Virginia School of Law. I'm not here testifying on behalf of the university, but in my own capacity and as someone who's spent many years representing exactly these kids.
Do you like the bill?
I don't like the bill, with all due respect to the patron, Senator Norman.
I'm still not honorable. Go ahead.
It's hard for us to break our habits. A couple of points. This is obviously a time in the Commonwealth when we have to be careful with the people's money. This bill has a fiscal impact.
Okay, I'm more concerned about the policy issue than the money.
I'll speak to the policy issues then. First of all, it takes discretion not only away from judges, which you've heard from the other witnesses, it also takes discretion away from the Commonwealth attorneys by making certain offenses over which they currently have discretion mandatory transfers if it's a second-time offense. Prosecutors have that power to send those kids to circuit court already without any judicial review beyond just finding probable cause. And so what this bill does is take discretion away from them. I heard the representative from the department say the point of this bill is to expedite the process. I just would like to reiterate what Professor McConnell said, which is it expedites the process at a time when we don't want it expedited because it means we'll have less information and make less effective decisions, and that it extends the process once they get to circuit court. I've heard that it takes on average 9 months to complete a case in circuit court between impaneling the grand jury and preliminary hearings and sentencing reports and all that. Kids are sitting in detention or jail that whole time. We're wasting the court's resources potentially on the wrong kids. The Crime Commission studied this for a number of years and received data from the Sentencing Commission. It turns out that 20% of the kids who get tried as adults just get put on adult probation, but they have adult felony convictions. Less than 50% get active DOC sentences, but have adult felony convictions. There are kids who need adult felony convictions, and prosecutors already have all the tools they need to secure them. What this bill does will just guarantee that more of the wrong kids get into the adult system and will be unnecessarily saddled with adult felony convictions, may unnecessarily face adult corrections. And the other piece of this, the Commonwealth Attorney's representative said this is a recidivism bill. National studies say recidivism rates go up for kids who get tried as adults and locked up as adults, not down. We should only want to do that when we absolutely have to, and there are all the tools necessary right now to get that done.
Thank you very much.
Thank you.
Good morning, sir.
Good morning. My name is Brian Gilbert. I'm the co-president of Students for Sensible Drug Policy here at VCU in Richmond.
Yes, sir.
We oppose this measure. One of our founding missions is that we oppose any drug policies which negatively impact youth, and specifically this measure we feel would specifically hamper these youths through this system. If we already have a system that's set up to deal with this measure, then why not stick with that system? And we definitely feel it would be a hamper on future educational opportunities and employment opportunities. So,
thank you very much for taking time out from your school to come here. Is there anything that has not been said that needs to be said? I see a whole line of you all there.
If I can cover something quick, I promise. My name's Lindsay Lawson. I'm a criminal defense attorney from Fairfax, Virginia. Before I was an attorney, I was a juvenile probation officer in Fairfax County, Virginia. What I've learned as an attorney is that there is unequal bargaining power, and that's something that I think you all need to be aware of. When I'm in the position of representing a child who is charged with one of these offenses for which he can be certified, my job stops becoming about protecting that child's constitutional rights, and it becomes about begging to get whatever outcome I can get from my client that keeps him in the juvenile court. There's no consistency. My outcome can depend solely on which prosecutor I happen to pull that day.
I think those of us that litigate for a living live with that every moment of our professional life.
Good. And the other thing that I wanted to implore you all to do is to trust your judges. Your juvenile court judges have the benefit of having that probation officer done a number of reports. That PO knows most about that child, and I would ask the court to trust their judges that you all have vetted.
Thank you very much. We appreciate it. Yes, ma'am.
Thank you, Mr. Chairman. Leanne Roselle from Families and Allies of Virginia's Youth. I want to make two additional points. We've been talking about the numbers, and I think we really need to be clear about how the numbers of kids affected by this have been falling. From FY 2007, 905, all the way to 403. So this is not like some emergency where things are happening that need to be addressed. Second, and I also want to note that there are people here who are part of our community organization, community members who are standing against this bill. And in part, one of the reasons that we're also against it is the disproportionate impact on minority youth of these transfer laws. When you're sweeping people in a mandatory way rather than giving them the individual consideration, that's part of what happens with this. Thank you.
Thank you so much, ma'am. I appreciate you being here. Yes, ma'am. Good morning.
Yes, good morning, Chairman and committee members. Carol Nago with the League of Women Voters of Virginia. And we want to focus on the fact that these are youth that we're talking about, and that we really urge keeping them in the juvenile system where they'll have the maximum rehabilitative services.
Thank you, League, for your continued advocacy. We appreciate it, ma'am. Yes, sir.
Good morning, Chairman. My name is Tom Fitzpatrick. I'm with the ACLU of Virginia, and I'll save your time by saying we also oppose this bill for all the same reasons articulated earlier.
Mr. Chairman, members of the committee, Kate Duvall. I'm an attorney with Just Children. I believe everything that I had to say has been said, and been said better than I probably would do. But what I did want to share
But you can't resist to add.
I just want to share numbers.
We are overwhelmed with numbers now. We've got the declining numbers. They're precipitous.
These are the intake numbers specific to these offenses from DJJ. I think the question was asked whether this was a need, and this is not a need. The intake numbers for these offenses have fallen by more than 50%
If someone would be
since
generous enough to get
2007.
that distributed to the committee members, I'd be very appreciative.
We're very opposed to this bill. Thank you.
Yes, ma'am. Last speaker. Yes, ma'am. How are you this morning?
Carla Peterson, Virginia Cure. I just want to say ditto to what Mr. Fitzpatrick said.
Thank
Virginia
you for
Cure
your
opposes
brevity.
this bill.
We appreciate it very much. All right, Senator Stanley.
Mr.
No,
Chairman.
we're not going to have any more questions. Senator Stanley, do you have any wrap-up comments?
Yes, Your Grace.
Getting close.
Upon review and some conversation with the representatives of the Secretary of Public Safety, and knowing that, Mr. Chairman, Senate Bill 583, which is Senator Edwards' bill, which is the first waiver bill, right of appeal, might solve these policy issues. I've had a brief discussion with the fine senator from Roanoke, and we have agreed, subject to Your Grace's agreement, to send it over to Wednesday to pass it by and perhaps combine those bills. The governor's office does not have
You
an
mean
issue
we've
with that.
spent 50 minutes on this bill and we're going to carry it over?
You know, I'm asking for the request, finally. This is my first one, Mr. Chairman. I guess I would. But I think it would take care of the policy issues if we can do that. The governor's office is willing to make that change, and Senator Edwards is willing to discuss that change. Just Wednesday.
Well, Senator Saslaw asked a very probative question, and I'd like the attention of the committee. Senator Stanley, I'll be right up front with you. I'm very respectful of your advocacy on this, and I know it's an important bill to the administration. I don't like the policy worth a darn of taking away from the judge. And so, and I've got a sneaking suspicion, being a reasonable nose counter, that there are a few others up here who are concerned by that. And so by carrying it over, are you suggesting that there's going to be some modification of that little poison pill that seems to be swallowed by this bill?
Mr. Chairman, I'd respond, and perhaps Senator Edwards can as well. His bill, if it were merged together, would allow for that discretionary appeal by the juvenile attendee certification. Not speaking to Senator Edwards' bill directly, but I do believe, Mr. Chairman, that that would solve some of the policy questions and issues that have been raised today. It would have ultimately the judge being the decider of that,
Mr.
of
Chairman.
that over the Commonwealth's attorney.
Mr. Chairman.
Dick, they are dealing with different parts of the process. They are not.
Mr. Chairman.
Senator McEachin.
Might I suggest that if that is the case, that when we get to Senator Edwards' bill, Senator Stanley can prepare some amendments and we can deal with those at that time? But I just assume, with all deference to my good friend, move to pass the bill by indefinitely.
Second.
It's been moved and seconded that Senate Bill 419 be passed by indefinitely. Is there any discussion on that motion or a substitute motion?
Question.
Hearing none, the motion before us is that Senate Bill 419 be passed by indefinitely. All those in favor signify by saying aye.
Aye.
All those opposed?
No.
No.
We knows.
If you would call the roll, please.
Senator Saslaw? Senator Marsh? Senator Howell? Senator Lucas? Senator Edwards? Senator Puller? Senator Obenshain?
No, actually passed by proxy this time.
Senator McDougal?
No.
Senator McEachin? Senator Stewart? Senator Vogel? Senator Stanley?
No.
Senator Reeves? Senator Garrett? Senator Obenshain? Senator Norman?
Aye. The bill is passed by indefinitely, and Senator Stanley, thank you and all the people who participated in this bill. And I would say to Senator Edwards, you may want to buckle up and take a look at that bill. Thank all of you in the audience who were kind enough to remain and participate in that. Senator Garrett, you have Senate Bill 461, sir. I don't see any way to cure that, sir.
Mr. Chairman, I would submit that if we debate this for an hour, something's gone horribly awry. Senate Bill 461 simply seeks to add hearings or proceedings conducted to determine whether or not someone is a sexually violent predator to the list of hearings that can be conducted via video teleconference. There's a consistent theme throughout a lot of our legislation this year that seeks to eliminate costs to localities. These video teleconferencing opportunities are already occurring within our courts. This just adds to the laundry list of events where the teleconference can occur, the adjudication of a sexually violent predator status.
Does any member of the committee have any questions of Senator Garrett on Senate Bill 461? Can staff attorneys, and I don't know, share with me, you know, what the Virginia or the United States Supreme Court, do they have any issues along these lines?
Mr. Chairman,
Mr. Benjamin.
The best I can tell you is that the Supreme Court has permitted the civil commitment of people after they have served their sentences only so long as it is for treatment and rehabilitation and is not viewed as criminal punishment, and so long as there are certain minimal procedural rights. The caution that your counsel has been providing over the years as this framework has been modified is that there may well one day come a day when the system in place is so streamlined and so lacking in procedural safeguards that the Supreme Court will declare it unconstitutional. I can't tell you that this is what will tip the boat. I have no idea. But one thing to bear in mind is that to the extent that someone has the right to the assistance of counsel during these proceedings, the use of video conferencing or a video appearance significantly deprives that person of his ability to communicate with and receive the assistance of his counsel. I guess a good way to look at it is the more that this system approaches being a rubber stamp of commitment, the less likely it will be sustained should anyone challenge it.
Does any member of the committee, excuse me, have any questions? Is there anyone who would like to speak in favor of this bill? Excuse me? I think it is. But he's right about the slippery slope deal. Yes, sir.
Mr. Chairman, Steve Whitmer with the Attorney General's Office. I've been asked to advise the committee that the Attorney General supports the bill.
Is there anyone else who'd like to speak in favor of the bill?
Eric Mattson with the Department of Corrections. Department of Corrections supports the bill.
Why?
The cost savings in transportation, the security of the offender during these procedures.
Thank you very much. Anyone who'd like to speak against the bill? Yes, ma'am.
Mr. Chair, members of the committee, Mary DeVoy with Reform Sex Offender Laws. Please bear with me for a minute on this. Our opposition to this bill is that it allows for the court to dehumanize the person in question. To some extent, the person on the other end of the video becomes an object, not a person. The exchange becomes a video game or a TV show. As we all know, prior to the invention of the webcam, people were generally respectful to those they addressed on a day-to-day basis. The webcam has allowed for unspeakable rudeness, bullying, and obscenity, which has diminished us as a society. The person at the other end is seen as an object and not as a person. Studies have been done on detaching oneself from a situation if they don't have to be physically present. In one recent study by a leading Harvard researcher on morality and the human brain, Joshua Green put a new spin on a classic moral dilemma. He asked participants to imagine they were standing on a bridge beside a large man overlooking a train track. A runaway trolley is approaching, and it will strike and kill 5 people. Is it moral to push the large man onto the track knowing that he'll be hit and killed by the trolley, but the 5 will be spared? Most participants said no, it's immoral. However, when the scenario was rephrased, is it moral to press a switch to open a trap door beneath the man's feet? Most participants said yes, that would be the right thing to do. This clearly illustrates that physically removing oneself from a situation makes for dispassionate and immoral decisions. The intent of this bill mirrors this moral dilemma, as it is quite literally removing the person. I've personally met with 9 residents of the VCBR, and they do not want these hearings done via video. They would prefer to be transported and detained for many days in local jails where they are housed with actual prisoners, many of whom have threatened and injured them because they are SVPs. Why would they want this? Simply because they want their day in court. They want to be seen as people whose only desire is to be given a chance to prove themselves. Judgment by video game is not true judgment. It's a first-person video game where the results have very real implications. True justice and consideration cannot be phoned in, but this bill allows for that as a reality. Imagine a trial where the jury consists of 12 video screens. This is not some lesser extent the very same thing? We understand the state is attempting to cut budget costs and initiatives, but if the person who is being considered for commitment doesn't want their hearing through a video feed, then the Commonwealth owes them their day in court. Thank you.
Before we vote on this, I must tell you, and it's probably not appropriate as the chair, but I take umbrage at this being characterized as a video game. I tried thousands, if not 10,000, criminal cases in my career, and many, many jurisdictions are currently using the video arraignments and stuff. They're not, and it is not just a cost savings mechanism, that there are safety issues that are involved on it. So I take umbrage as suggested as a video game. Senate Bill 461 is before us. Is there a motion? It's been moved and seconded that Senate Bill 461 be reported. Is there any
Mr. Chair.
discussion on that motion? Senator Howell.
Thank you, Mr. Chairman. I did want to just express my concern with the direction we're going here. The whole civil commitment process passed the Supreme Court on a very narrow 5-4 vote. Mr. Benjamin has, I guess, been pointing out the slippery slope aspects of this, but I'm looking at it from a different perspective, which is of the person who has served his term, who is now going to be committed for what will probably be life or close to life for something he actually hasn't done. It's a very difficult issue. And I think if we're going to do that to somebody, we really should do it in person. Thank you.
Mr. Chairman,
Senator Marsh.
when asked to justify why the Department of Corrections supported this measure, he said money. It cost it. I mean, that's no reason to support a bill that would subject people to possibly life in a situation.
I don't disagree with you, Senator Marsh. It's been
Mr.
moved
Chairman,
and anyone else in the committee
very
like to be
briefly.
heard? We're good. Anyone else like to be heard? It's been moved and seconded that Senate Bill 461 be reported. All those in favor, please signify by saying aye.
Aye.
Aye. All those opposed? And if the noes would make themselves known, please. You got it? And the bill is reported by a vote of? Senator Sasslaw voted aye. Now what's the vote? Okay, the bill is reported on a vote of 9-6. Senator Garrett, trying to get you wrapped up for the day. I see you have 668. Is that correct?
Yes, sir, Mr. Chairman. Essentially what 668 does is it allows substantially similar offenses, and most of the folks who are either law enforcement or attorneys on this committee will be familiar with the concept of substantially similar offenses from other jurisdictions to be included for precursor offenses prior to a mandatory felony conviction under a number of sex offenses. But what brought rise to this was essentially exposing oneself. And what we have is a circumstance where, for example, if you have a DUI conviction in Tennessee or Maryland or Washington, D.C., it would count as a substantially similar precursor offense towards counting towards the felony DUI third. Whereas, and I have with personal experience and also from the Commonwealth Attorney's Office in the city of Lynchburg, seen instances where we have habitual flashers, for lack of a better term, who are convicted in other states and are substantially similar code sections, and those don't count in Virginia. So it simply would add that if you're convicted of indecent exposure in Washington, D.C., that would count towards your 3 strikes in the Commonwealth of Virginia.
Does any member of the committee have any questions of Senator Garrett on 668? Is anyone who would like to speak in favor of the bill?
Mr. Chairman, Mike Doucette, Commonwealth
Yes,
Attorney
sir.
for the City of Lynchburg, and as Senator Garrett has said, this is an actual incident that came up recently here in the City of Lynchburg, where we had somebody call him a flasher is nicer than I called him, but we had where the priors were from out of state, and we were not able to build a recidivist charge based on the out-of-state priors, where we could have if the priors had occurred here in the Commonwealth of Virginia.
Is anyone else who'd like to speak in favor of the bill?
I have a question, Mr. Chairman.
Senator Edwards, yes, sir.
Either one. So all this does is say you can use out-of-state priors, whereas currently you can use in-state priors only. Is that right?
That's correct, Senator Edwards, and it's the same concept as we have with, for example, DUI laws.
Thanks.
Is anyone who'd like to speak against the bill? Hearing none, Senate Bill 668 is before us, and if the committee is so inclined to report it, it needs to be reported and re-referred to Finance.
Second.
It's been moved and seconded that Senate Bill 668 be reported and re-referred to Finance. Is there any further discussion? Hearing none, all in favor, please signify by saying aye. Aye. All those opposed, and that bill is, make your noes known, please. Senator Marsh? The bill is reported 14-1.
I don't know how Senator Lucas would vote, so
I'm sorry?
I can't vote for Senator Lucas.
The
I don't know how she
vote,
votes, so.
bill will be reported 13-1 to 1.
Right, thanks.
I think, ladies and gentlemen, with that, I will suspend. I will say that there are several patrons, members of the committee, who have bills that were not taken up today. And when we meet on Wednesday, you might notify the sign-up patrons perhaps to come. Let's move it back like 30 minutes, and I'll take the members of the committee on the bills that were not taken up today to try to get those out of the way. And once again, I apologize to the committee for my ineptness in taking up much of the time this morning on the proxy issue. Thank everyone for your attendance. With that, the committee will rise.
Oh, no.